Make me do it. We have few lots in the to mention one item. This may come on Friday or
What?
at any
What?
for admission.
No, no. For all pending matters, please go to the registry first.
Right.
All pending matters, all mentions, please go to the registry. We are having a problem otherwise. Because
I do that.
all matters are not being discussed.
My item was supposed to be listed in the month of January. It is not listed.
Go to the registry. Go to the registry.
Item number 40, had one affidavit appointment that may be called for.
Item 40.
440, yes.
Lordship, with respect to, I beg to mention item number 32 and 33. With respect to the other.
Yes.
Lordship, in this matter, in item 33, Lordship, we are, I need some, Lordship, 2 weeks time to file counter law in 33.
You're for whom?
I am from IIT Guwahati, Lordship.
Huh?
That's number 3 to 5 in item 33 and item 32, Lordship.
You have to file affidavit where? In which writ petition?
In second petition.
That's enough. Don't talk about the other. Yes, who's for the petitioner?
I am for.
Any objection?
Yes,
But this is only with regard to the you returning late, correct? Due to COVID.
yes. Late due to COVID.
Due to COVID, you came late,
Yes.
and so now you have, unfortunately, you have left the job.
Because
So-
there is a tussle between
Correct.
that is why, Lordship.
What do you want to say?
Lordship, in item 32 already we have filed our
Then 132 cover 33.
30
Yes,
is
Lordship.
new
Huh?
issue. 30 is new issue because we have already proceeded disciplinary proceeding law, and that is paid.
After
by
3 years.
Honorable.
Disciplinary proceeding, you see, that is a different issue. Now the issue is with regard to whether she should get paid or not, and whether she should repay you. She's saying that she doesn't mind repaying the amount, correct?
I entitled some amount.
Provided you get your entire.
Yes, yes.
So
Lordship, our affidavit is very Lordship. We have already sent for waiting Lordship. I need 1 week time.
Yes, Lordship. 2 weeks time may be given, and in the
I
meantime,
mean, but why? Is it was COVID time? You also, if you were stuck there in some European country, there were no flights. How will you come back?
yes,
Swimming?
Lordship.
You'll have to
There is
swim
some
all the
decision
way.
of the Supreme Court also.
Anyway, right. On the prayer of Mr.
Yes, sir.
S. Tushadhar, who submit that affidavit in a position in WPC 5243 of 2024 is ready.
Yes, ready. We have sent for waiting Lordship.
Has been sent for vetting, and the same will be filed within
Within 1 week.
a week. This is the matter after a week. Next, right. The matter pertains to the petitioner having gone abroad for further study. Is it? No, for to
Yes,
attend for
yes.
further study
Yes, Lord.
for the period from 22/7/19 to 10/6/2020 after obtaining due permission. So, however, due to COVID-19, he could not return in time. The petitioner has been asked by the authorities to return the expenditure incurred, is it, for going abroad to the tune of rupees 25,29,436. So, on the other hand, the case of the petitioner is that though she is willing to pay the amount claimed by the authorities, the amount due to the petitioner amounting to rupees 24,49,538 should also be paid. Correct?
Yes,
So you'll have to pay an extra 1 lakh or so.
I'm ready.
This is the matter. after a week.
Interim order
Interim order to continue till the next.
in second case. Item number 30.
It is joined together.
Obliged.
May I please your lordship?
Yes.
For listing lordship, similar matter listed, before, listed on, already before this honorable court lordship, series matter, so kindly matter may be taken along with that matter lordship.
The series matter
Lordship,
that
before to, 25.
apportionate upon.
May I please, Your Lordship? Well, I'm praying for listing one of matter for withdrawal lordship tomorrow.
May I please, Your Lordship? I will mention item number 8, 10, and 11, Your Lordship. The matter may be adjourned for the day, Your Lordship.
Why?
Lordship, I am on behalf of Mr. S. Ali. He is out of station.
Where is he?
He has gone to Dibrugarh, Your Lordship, to meet her, to meet his daughter. So he's out of station. Any day, any Wednesday or Friday, any day may be given.
You're right. Adjournment prayer has been made on behalf of Mr. S. Ali, current counsel for the petition. The matter pertains to the claim made for one advance increment for acquiring PT/BEd degree in terms of the OM dated 7/3/98. The similar matters appear to have been disposed of by this court. However, the fact remains as to whether the delay in filing the writ petition could have an effect on the claim of the petition. The petitioner would have to inform this court as to when he joined his post and when he acquired the PT/BEd. This is the matter. When?
Wednesday or Friday, Your Lordship. 25.
Date, tenant. In all, you put the same thing, same issue.
May I please, Your Lordship? Lordship, I beg to mention item number 26, Your Lordship.
26 days.
The matter may be adjourned for 2 weeks, Your Lordship.
Why?
Lordship, Mr. S. Gora is now appearing for Sarva Shiksha and Mr. A. Ganguly.
Huh?
Mr. S. Gora is appearing for Sarva Shiksha nowadays. And Your Lordship, Mr. A. Ganguly has some personal difficulty today, Your Lordship. And he won't be available till 31st, Your Lordship.
No, I'm not adjourning. Sorry.
May I
Do
please,
it.
Your Lordship? Lordship, prayer for listing of a contempt matter, contempt matter, Your Lordship. Listing of contempt matter, any date next week, Your Lordship. Last is 6/11/24.
You go to the registry and ask.
Obliged.
May I please your lordship? I'm for listing a late petition. Last listed,
Registry, go to the registry. You go to the registry. Yes.
Lordship, beg to mention item number 18, Lordship. This matter wrongly listed before this bench, Lordship. These are division matter, Lordship. We have challenged it.
Yes, you challenge the rules. Yes. Right. Mr.
As Procedural, Lordship.
Appearing for
B. Purakasa.
Mr. S. Sutardar, appearing for Mr. B. Purkaisa, current counsel for the petition, has submit that the matter should be placed before the division bench in view of the fact that the challenge is to the Assam District Institute of Education and Training, bracket diet, right close, service rules 2010, which has been made under the proviso to Article 309 of the Constitution. Registered to according to this matter before the
May I please, Your Lord? I beg to mention an item withdrawal for tomorrow. Public.
May I please? The concept of data site, I beg to make an number 22, Lord.
20.
22, Lord. The document kindly adjourned this matter for 2 weeks, Lord, as my senior is out of station. for medical purpose.
Yeah, I have found that you have been adjourning this matter a lot of time.
Only this time,
Why?
because my
Why
client
2 weeks?
he will
Why
be
2
coming,
weeks?
he will be coming on the next week.
She'll be coming next week. So why do you need 2 weeks? Where is she?
In Mumbai,
Mumbai. Who's the counsel's name?
from B. Puya. MS
Yeah. Sometimes Miss N. Barwa appears, sometimes Miss B. Bhuya appears.
And Burwa, I don't know. I thought
We'll list it next week, no further adjournment.
Aye.
On the prayer for adjournment made on behalf of the petitioner, Ms. Counsel Ms. B. Bhuya, this is the matter on Monday. No further adjournment will be given on
on Tuesday, my lord, kindly, my lord.
Huh?
Tuesday, my lord, kindly.
no, Monday.
Obliged.
Here, my lord, our affidavit is ready, my lord.
Affidavit ready.
Ready,
My
my lord. On Friday, my lord.
What are you challenging, Mr. Counsel? What are you challenging?
My lord, in this case, lord, the present president of the state school management committee, my lord, is not discharging his duty, my lord. And my lord, the case is pending since January 2024, my lord. So, my lord, matter may be disposed of by directing the director of elementary education, my lord. So, hold an inquiry, and in the meantime, my lord.
Huh?
All the allegations are false, my lord. He has stated only 23.
I know, and where is the SMC? Is not even a party. The school management committee is not even a party here. Where is your case?
And kindly see his annexer, page 19, my lord. The photo,
Page 19.
19. He is sending it through WhatsApp, my lord. As per the notice, my lord, meeting was to be held at 11.
What is this? I don't know. This is in
This is a-
Assamese or what?
This is a photo he has forwarded stating that he admitted in the hospital, man. My lord, thereafter kindly see, my lord, next page, advice slip, page 21. No name is there, no OPD, registration number is there. Only, my lord, this.
My lord, as per Rule 13 of Assam Right and Compulsory Free and Compulsory Education Rule 2011, my lord, the headmaster has to give notice before 7 days, prior to 7 days. My lord, but in this case, my lord, the headmaster issued notice on 7, holding the meeting on 9/11/2023. That's 2 days before the meeting, my lord, which is a clear violation of the mandate rule.
Mr.
my lord.
Counsel, you want to set aside the resolution passed by the general meeting held in the held also and so constituting the school management committee,
Yes.
correct?
Yes.
Where is the school management committee? Are they a party here?
The headmaster was made.
I'm dismissing your writ petition. No case. You want to set aside the school management committee. The school management committee is not even a party in the writ petition. Where is the question of allowing your writ petition or considering it? You've got no case. Supposing I want to say that you should be kicked out or your license as a lawyer should be cancelled. Can I file a case against you without making you a party? Tell me, can a person be condemned unheard?
That we may be allowed to make party, my lord.
You withdraw. I'm dismissing myself. No case. There are lots of other. I don't have to tell you. There are lots of other mistakes. Sir. You withdraw with liberty if you want. Mr.
And Jaman.
N. Jaman, learner counsel for the petition. Submit that. He would like to withdraw the petition with liberty to file. Mr.
PK Bora,
P.K. Bora appears for the
elementary.
elementary education. The prayer of the petition council is allowed. This petition has withdrawn from with liberty. I think I've got to do a little bit more homework. Yeah, The main thing itself is the person you are challenging is not a party here. There are other aspects also which I will not go into. To wasting my time. But unless you correct the other issues, when you come next, it will be most probably dismissed on the first day. You have to be careful. Please read a little bit. Yes,
Well, we have,
yes for whom?
I'm for the respond number one, my lord.
Oh, very fast.
It is, my lord, notice issued, my lord, on 2012-2024.
So it has been complied with or what?
Yes, we have done our part, my lord. We have forwarded the pension proposal. That entire proposal I have given.
You have done your part.
I have done. My-
Let me see in the writ petition. Who are you?
I'm the principal of the school, my lord.
Your principal. So only you are a party. Only you are made a party.
No, my lord.
Another
Inspector of
response.
schools was also made
Respond number two, my lord.
Who is appearing for point number 2?
Nobody has filed Wakalat Nama yet.
Okay, right. Mr.
Be prepared.
P. Purkasta appears for the respondent number 1 and submits that the role of the respondent number 1 is over inasmuch as the pension proposal of the petitioner has been submitted by the respondent number 1 to the Director of Pension Assam by letter dated 15/3/2020. But then acha, to the Director of Pension Assam through the Inspector of Schools, KDC Amingaon by letter dated 15/3/2020. No one appears for the respondent number 2, next para, who is the Inspector of Schools. Office note dated 3/1/25 indicates that notice was issued to the respondent number 2 on 3/1/25. However, there is no return of waiting card or unserved notice with respect of respondent number 2 till date. What is to be done?
My lord, the the thing which has to be done by respondent number 1 or the respondent number 2 has just to forward the pension proposal to the director.
So, what do? Do we close this or what?
But we can close it if the whole pension is the pension paper has been forwarded. Then
Full stop. Mr.
yes, Rabha.
S. Rabha, learned counsel for the petitioner, submits that as the respondent number 1 has forwarded the pension proposal of the petitioner to the Director of Pensions through the Inspector of Schools as submitted by letter dated 15/3/2025 issued by the respondent number 1. The contempt petition can be.
My lord, if uh, let them bring the same through an affidavit, my lord, then at least a record would be there.
I'll make this a part of the record. In view of the submission made by the counsel for the party and as the process for payment of pension, as the proposal for payment of pension has been initiated from the contempt petition stands. The letter dated 15/3/2025 and the annexures issued by issued by the respondent number 1 and the annexures are made a part of the record and marked as annexure X collective. So if you want, you can have, have you got a copy? You've got. The contempt petition stands closed.
Your lordship. Application
So this is enough. It will be paid to him. Well,
in the period of 2 months,
should be
payment
paid.
will be delayed.
Heard Miss A. Sharma, learned counsel for the petitioner.
A Pujar Gora,
Oh, A.
Pujar Gora.
Pujar Barwa, sorry. Whatever name I see here.
Last occasion,
Okay, yeah. Heard Mrs. A. Pujar Barwa, learned counsel for the petition. Mr.
PK Boraman.
P.K. Bora appears for the elementary education
My
department.
lord.
The petitioner's case is that the petitioner has not been paid his arrears salary
from November to February.
from November 2020 to February 2020, amounting to rupees 6,13,90. For the no, while working as
Working as a Hindi teacher, but
Hindi teacher in
in ASB member.
ASB Memorial School, Hailakandi, Aranaipur, Ranaypur school. Huh? Mr. P.K. Focus has submitted letter number EAA/B/55/2023/53 dated 1/3/2025 issued by the Director Elementary Education Assam which is addressed to the Secretary to the Government of Assam Department of School Education, Dispur Board. Requesting the government to accord sanction for rupees 6,23,67 no 37 623,376 as arrears salary payable to the petitioner. The letter dated 1/3/2025 is made a part of the record and marked as an extra act. The contents of the said letter dated 1/3/2020 is also reproduced herein below as follows. From subject to it says two from. In view of the, the fact that the respondents have admitted that they are liable to pay the arrears salary of rupees 6,23,376 to the petition in terms of the above letter, the respondents are directed to pay the same within a period of 2 months from the date of receipt of a certified copy. The writ petition is accordingly disposed. Any take? Bless.
May I please ask? So the matter pertains to the non-compliance of protected 21/1/2025, passing WPC number 5108/2022.
Okay, heard Mr.
M. Dekal.
M. Dekal, learned counsel for the petitioner who submits that regularization of the petitioner's service has not been done till date, in spite of the order dated 21/1/2025, passed in WPC 5108 of 2020. Issue notice returnable in 4 weeks. Petitioner will take steps for service of notice upon the respondent by registered post daily within 3 days. This is the matter.
Like, right? These are- On the last occasion, my lord, instructions were called for from the respondent 1 to 3 months.
Your Lordship, they have issued one letter for submission of fresh arrear proposal in respect of the petitioner.
Who is to submit?
Your Lordship, Inspector.
Can you give me that?
Deputy Director has forwarded the letter.
So when is the proposal going to be submitted?
1 week time may be granted, Your Lordship.
Right, Miss Pidas, learned counsel for the
Respondent
Secondary
1,
education.
2, 3.
respondents 1 to 3 submits that the Deputy Director of Secondary Education has written a letter dated 13/3/25 to the Inspector of Schools, NDC Nagaon, requesting him to submit a updated fresh area proposal with all supporting particulars in respect of the claim for area pay in respect of payable to the petition. He accordingly submits that he needs a week's time to obtain further instructions as to whether the updated fresh area proposal has been made by the inspector. This is a matter when
Friday next week.
When?
28th
When they-
March. DPO.
May I please, Your Lordship? Lordship, the last occasion, my Lordship is directed to go to the Horendra Chandranath case, my Lord. Thereafter, my Lord, in this case, what happened? Relying on the same judgment, my Lord, one of the learned singles of the court dismissed the case, Horendranath, and that petition before the division bench. Division bench setting aside the single judge order, remanded back this matter. Then that is pending. The division bench, what order passed subsequently, I'll have to place before this court.
And Harendra Chandranath is by how many judges?
Two judges. And the first read appeal, my Lord.
Is it?
Yes, read appeal.
Yes, it is.
And the 13/12/2022. At WPC 222/7/19, it was challenged.
Yes.
May I read the order, my Lord?
Yes.
From paragraph 3, I'll read.
Yes.
The appellants herein are working as assistant teachers in various lower primary schools in the district of Kokrajhar, Assam. As the record unfolds, they were initially appointed on honorary basis in pursuance to the order so passed by this honorable court. The service of the appellant came to be regularized as assistant teacher by PTC authority, and they are posted in lower primary school. It is the case of the appellants that they were paid salary with effect on census, but no salary was paid to them for the period from 1/1/2005 to 22/12/2014. And hence they approached this court by filing a petition for release of their salary for the aforesaid period. Various contentions were raised as such by the both sides, which is evident from the record of this appeal. However, the learned signatures came to conclusion
that the writ petition was filed by the petitioner only on 19/3/19. That is after 4 years, 3 months from the date of receipt of their salary, and that too without an explanation for the delay. The learned single judge was of the opinion that no directions can be issued for release of such arrears salary beyond the period of 3 years prior to the filing of this claim. While coming to the conclusion of the learned single judge has relied upon the judgment of the Honorable Apex Court, the Union of India utters and reported the judgment and division bench of this court, the referendum under not reported. According to learned single judge dismissed the petition on the ground that a monetary claim in the writ petition can be made for the period of 3 years preceding the date of filing of the writ petition. Having heard the learned counsel for the parties and considering the various contentions which were raised before the learned single judge, we find that the learned single judge has not considered the same and has dismissed the writ petition only on the ground that the claim is raised by the petitioner after a period of more than 3 years. Paragraph 7. Considering the facts that the issue of the entitlement of arrears salary as prayed for by the evidence could have been examined in detail, and further considering the contention raised before us, it is in the opinion of this court with respect with the learned single judge has committed an error in dismissing the writ petition only on the ground of the claim having been raised after a period of 3 years. In totality of the facts, therefore, while disagreeing with the observation made by the learned single judge in the particular fact of this case, we deem it fit to quash and set aside the impugned judgment and order remand that proceeding back to the learned single judge the request to hear both the sides and decide the petition in de novo in accordance with law, without any manner being influenced by the observation made by this learned single judge or the observation made by this court in this order. As the matter is of the year 1919, the learned single judge requested to give priority to the matter and dispose of the same expediently as possible if it is allowed and enforcing them. With this direction, my lord, next another order, my lord, the single judge has received that remanded order that is on 4/1/2023 passed by the learned single judge, and accordingly, my lord, this matter fixed on 26 March 2025 for final disposal. This is the order, my lord. I failed to give lordship. This is the final order, my lord. Next date posted on 26 March. So mine, this present matter may be posted along with this matter on 26.
They are different case. Out here is different. Out here they came to the court in 2002.
And
Your writ petition is of 25.
my lord, here I am relying, my lord, since even official authorities are not disputing that I am not entitled. Time to them, they have also communicated to the department, my lord, ventilating my claim, my lord. And finally, my lord, 3 applications I prefer before the authorities concerned, not even whether
Just a
I am
minute, just a minute, just a, there's no point talking fast and without making sense. This 2013. Hmm.
it went.
To move here, sir, अपनी affidavit file करें. Your lordship, I would like to draw your attention to the annexure 3, page 17 of their writ petition.
Yes.
Above your lordship higher secondary examination, there is a overwrite
Ah,
your lordship,
overwriting 1990. Yes,
1990.
out here
And
also there's
your
overwriting.
lordship passing certificate also, your lordship overwrite
These are
is
all
showing
original
your
testimony
lordship.
I have brought.
And it was,
I'll file additional affidavit.
and your lordship, and your lordship 31st May 2024, your lordship.
Correct. I see.
Issuance of-
Yes, this is.
Before that,
Let me
your,
file a affidavit object on, but I could file a reply on this point.
before that, your lordship, he could annex the original one before annexing
Let us
this
see
one,
the
your
original.
lordship.
The mark sheet also given, my lord.
And it can be
Where
clearly
is your
seen
page 17
overwrite
original?
has been made.
That
This
is
one?
there, my lord. 2014, he received this, applied that, debtor, my lord, then received this one.
You passed your exam in 1990
90.
Absolutely.
and you joined your post when?
My lord. 88.
Yes.
88. 1988. my lord.
88.
Yes, my lord.
So you passed in 88.
Yes.
You joined in 88
88 joined.
and you passed your class
Higher secondary 1990.
in 1990.
After 2 years.
After 2 years you passed.
Yes, my lord.
And you joined as what?
My lord, as assistant teacher, my lord.
Assistant teacher. What is the qualification required?
At the joining matriculation, SSLC pass. But subsequently, I passed SSLC, higher secondary. Then, my lord, there is condition in my
Where
appointment.
is your HSSC certificate? Is it here?
My lord, the annexure 1, page 14. Page 14A, my lord, the original order.
Your lordship, I didn't receive 14A. It was after annexure 1, page 14. I straightly coming to annexure 2, 15A, and there is no 14A.
Textbook. Textbook
No idea.
14.
Nothing has been given in my writ petition.
Because the 14 subsequently it is type copy, the original one.
No, you give 14.
What is reflecting in my writ petition?
have to-
I am
you see,
stating that only.
You cannot, you have to give all the documents as you file to the lady, to the other side. You cannot duplicate.
Now I'm giving, you know, in front of
Give,
council,
give,
I'm giving,
give.
you know.
Please give.
Yes,
Why not give earlier?
right now.
Let me see what he has given you. Look, appears to be same. Yeah.
Don't give you. Mo itu ada tu. Kenapa? Apa tu right?
Where is your class 10 certificate?
But the process certificate is not yet for higher secondary.
Can you bring your class 10 certificate? I think you've got to produce a class 10 certificate. Original.
Sure.
Right.
Can I file additional affidavit?
You file additional, you bring original
Yes,
also.
yes, yes.
Mr. P.K. Dekala, counsel for the petition, shall produce his original matriculation certificate and also file additional affidavit. If and also file the as paid for by. This is the matter. When?
After 2 weeks.
Give a date. Yes, sir. The issue as to whether the petitioner can claim the fact that the petitioner has retired in the year 2016 and has also made a claim for, we don't have a case. And I also made a claim. To be paid intermediate pay scale for a period of more than 20 years ago would prima facie be hit by the judgment of the Supreme Court in the case of Union of India and others versus Tarsem Singh, reported 2008 SEC 648. And in the case of Harendra Chandranath and others versus State of Tripura and others, 2013 2 GLT 109. This is the matter. Give it that way.
Can I get photo of it?
Keep your.
Item 7.
Nebula.
Can you back the item?
Alert 7. Similar method method is pending method.
This is with regard to old pension.
Alert another inclusion page 17 pilot
Page?
page 17 pilot notice. Matter is pending.
Where is this? Where is this WPC 6403/2021?
Equal unity mallet. This is mallet another judgment mallet. There are mallet number of judgment mallet.
Show me the 6403/2021.
It is Purnima Hore mallet.
Purnima.
Hore mallet. It is mallet against that mallet. And against this judgment mallet, there is a repeating is pending. Mallet 156 2025.
One five six.
Mallet
Against that Purnima Hore.
retail bill 1
So,
6 156 2023 mallet.
so Purnima Hore is not in your favor.
No matter.
Yes.
Mallet there in this case mallet Purnima Hore mallet mallet certificate part is
Ah.
certificate part mallet certificate part is not properly. Therefore mallet we have file mallet retail bill. So there are mallet num there mallet better mallet. There are mallet yes mallet lordship part there judgment file review also. Mallet there is a mallet provision mallet certificate and constructive certificate. And this aspect was not properly executed by the single judge mallet in WPC number mallet 6403. And in that area mallet we have filed retaping. Retaping is pending mallet. Filed mallet retaping number 156. And here mallet another inclusion matter is pending mallet. I have the next mallet is order. Mallet page 73 mallet. After received notice mallet got a and recently, another development is there, my lord, in our paper, my lord, government has one communication, my lord, very recently, my lord, in the year 2023, my lord, there, where, my lord, it was, my lord, there for already instructed institute, my lord, to give old pension to the, my lord, employees, those whose, my lord, regularization are processed before, my lord, coming into course of new pension. Page 7.
But as on date, Purnima Hore's judgment covers you.
Yes. They are connected, my lord, in that court, but the deputy is pending, my lord, similar matter to the so pending, my lord. Therefore, I am praying.
No, why should you see there? How can we do that? You cannot have single bench matter and a division bench matter on the same issue going together.
Yes, sir.
How can you do that when it's a covered matter? Yes, madam.
Well, Purnima Hore is related to stability, Mallard.
Huh?
Purnima Hore is related to stability, Mallard. It If your lordship may come page 40, my lord.
Stipendary,
They are my lord drop teacher, my lord.
but they are
If you
drop
are-
teachers.
drop-
Excess.
Excess drop teacher, my lord.
Excess. No.
And my lord, if your lordship paid page 76, my lord.
Page
you-
76.
Communication of the government, my lord, those will only give the benefit, my lord, who were appointed before 1/1/2005, my lord. And the petitioners are regularized in the year 2011, my lord.
Oh.
The process, first,
No, no. So what is your case now? You see, you want the old pension rules to be applied to you, correct?
Yes.
That Purnima Hore says that drop teachers are not entitled to old pension, correct? Then what remains? You are a drop teacher. You are an excess teacher.
Drop teacher.
Huh?
Drop teacher, my lord.
A drop teacher. Drop teachers. There, how many types of drop teachers?
Only one type.
No, no. Please, I don't think. I don't think that. I think there might be two types of drop teachers. I don't try to. Please don't try to lead me up the wrong garden path, because if I find out later on that you are trying to lead me in the wrong garden path, you're going.
This is, I am sure, my lord, only one time of drop teacher which called my lord in the matter 19th, my lord. Who was my lord professor, I my lord with immediate teacher.
Give me that Purnima Hore's case.
First kind of page 76. Page 76. With reference to the letter of the subject cited above, I am directed that the in the letter referred to above the line at point number 3 appears whole paper be allowed to those government employees whose recruitment process and started before 1/1/2005. It as appears be allowed to those government employees whose recruitment process had started before 1/1/2005.
Give me the Purnima Hore's case. Okay. Give me the WPC 6403 of 2021. How much judgment? How much?
4,500.
Oh, 4,500 pages. Oh, two. Wait, I think I've got it somewhere.
My lord, main part is my lord there.
Huh?
Main part, judgment part is my lord there. Part is there are number of parts.
I just want the
40,
the
50 page.
how much?
40, 50 page.
Just print out. You see, the thing is this. We have to see one thing. There are stipendary teachers. Then there is a excess teachers. Excess teachers, I think, are those who have been appointed against non-sanctioned posts. Where is your case then?
Comparison blackboard teacher.
So do you come under those non-sanctioned? Were you appointed against
Drop teacher. Purnima Hore is also Kabari for a drop teacher.
drop teachers, but dropped? Yes.
Purnima Hori is only for my lord stipend teacher, not for drop teacher.
Okay. Purnima Hore is only for
Stipend
stipendary teachers, and petitioner is
drop teacher.
drop teacher.
My lord, if you also paid page 40, my lord, it is
Page
descriptive,
40.
Page 40, my lord.
Yes.
In exercise of power conferred upon the Director of Elementary Education, Assam Government, letter dated so dated 4/1/2002, and in persons of the government, letter dated so in continuation of the letter dated 6 July 2011, following drop teachers are hereby regularized. So they were regularized in the year 2011, against the vacant post of
The vacant person
in
okay.
compliance of the High Court
So
order
they regularized in the year 2011.
11.
So
If your lordship paid page number 76, here only those have get the benefit who were appointed for 2005, 1 or 2005.
Main judgment, my lord, page 21. It is the Jivotchandra data, my lord, where it was provided that, my lord, there should be given whole page. Page 11 for my lord, page 24, but last slide. All the appointments made to the prospective part carry the benefits of past service for the purpose of
pension.
without giving that kind of whole pension, it was they cannot give us the past. And retail judgment, my lord, pays 68%.
Yes.
This judgment was upheld, my lord. Plus provided.
Yeah, drop details again. Okay, we need to notice. Heard Mr. A.M. Barbayan has asked for the petition to submit that the petitioners should be given the benefit of the Assam Service Pension Rules 1969 and not the new pension scheme. In as much as the past service of the petitioners were to be counted for the purpose of grant of pension. Issue notice returnable in 4 weeks. Ms. S. Tutti accepts notice on behalf of
1, 3, 5, 6, 7, and 8.
1, 3, 5, 6, 7, and 8. Ms. M. Barwa. Oh. You. Mr. R. Bora for response number 2. This is the matter of 4 weeks. Enable them to enable the respondents to file the reference.
Right. Keep them on. Mr. It is better. The FJ Madhukar.
Huh?
Mr. FJ Madhukar, we are like put number 1 below. Better. Simple.
Right, please, Allah. My lord, I will pay 19, right? The Indian, my lord. Has been reinstated the original post, my lord. The order started on the basis of an inquiry, my lord. The inquiry, my lord, will find it page 12, my lord, starting from page 11. Under
What right of yours has been
I'm the
violated?
SMC president, my lord. I'm the SMC president. My lord, before going to this, my lord, just have a look at the inquiry conducted, my lord, and the finding of the officer.
So you have filed a representation
I have filed the representation.
for what?
My lord, representation starting from page, the first representation that I have page 20, my lord, and then along with the whole SMC members starting from page 24. My lord, it is a surprising kind of event, my lord. The inquiry, my lord, has categorically stated that the action should be taken against this certificate.
Where is that?
My lord, will find page 19. The inquiry order.
You see, we cannot do administrative work. That will be very clear.
My lord, the finding, my lord, page 12, my lord, the type book, my lord, he has already misappropriated amount 50,000.
We don't know. That is their
And then, my
allegation.
lord, can come to the finding, my lord. What the officer who has done the inquiry, my lord, has categorically page 12, my lord, 12. Original is page
Yes,
13.
where?
Yes,
Which
the last
para?
paragraph, my lord.
Huh?
Last paragraph.
Yes.
From the interaction with the SMC and some local people, it has become clear that there is no good relation between the head teacher and the other SMC members, which may deteriorate in the condition of the, and the head teacher, member secretary may be changed with any other AT of the school for good academic environment of the school. And action may be initiated against the so-and-so present AT of the school for withdrawing money with the old SMC president by ignoring the legal. And he, my lord, on his own, page 17, my lord, he has resigned, my lord. And then thereafter, this Sikarani Roy, my lord, senior most speaker has been appointed. But unfortunately, my lord, by page 19, my lord, he has been reinstated. Page 18, my lord, in his own handwriting, my lord, the type copy, my lord, you find at page 17. He has resigned.
You you go to the director.
I have already gone, my lord. These are the representation I have submitted to the school authorities, that my lord, that all the respondents, my lord, the commissioner, the secretary of the government of
No, you cannot be a busybody.
There is no sign of the officer also pages page 20, ma'am.
Page 20.
My,
Yeah.
there is no signature of the authority, ma'am. Where it is.
Where is the receipt?
Receipt I have, my lord, they have provided with the receipt.
You go and file there.
Receipt is there, my docket number is there.
Where? Where?
I have, my lord.
You have it, you keep it, frame it in your wall, put it in your bedroom. For you to see only, you keep it there. You pray, you paste, you make a copy of this writ petition and you paste it in your wall, in your bedroom.
See the page 24.
What is this? What is this? You have it. Naturally, you have it. You are supposed to
Docket-
bring everything to
docket
this
number
court.
is also there, ma'am.
Huh?
Docket number is also there.
Mr. Counsel, there is no point keeping everything in your safe, in a wallet, and keeping it safely for only you to see. What has the Supreme Court said? Supreme Court has said when you come into a writ court, you have got to produce all documents. You cannot play hide and seek with facts.
Here, my lord.
You carry on playing hide and seek with facts. Why should we bother?
My lord, I have not have document.
You go to the director. You go file a representation.
My lord, that direct, my lord, representation will be disposed of. With what definitely will affect representation.
You have not even filed a representation to the
No, I already
director.
filed, my lord, but I
Which one? Which one?
both the representation.
Where is it in your writ petition?
Number is not there, my lord, that's the reason.
Forget docket number. Where is the representation to the director?
Here, my lord, to have not filed to the director.
You have
the
not filed. You
immediate
file it.
authority
You
will-
go and file. You withdraw and
Here, my
file.
lord.
You withdraw and file. Mr.
Yes, my lord.
is Tapatal Counsel for the petitioner. Submit that he may be allowed to withdraw the writ petition with liberty to file a representation to the director with regard to his allegation that with regard to his grievance regarding the reinstatement of the petition, reinstatement of the respondent number,
Six, my lord.
respondent number 6, as in charge academic head teacher of which school?
My lord, 517 Patmar Park, Sri Ram Krishna.
Miss S. Tuti appears for the prayer of the petitioner's counsel is allowed. The petition is dismissed as withdrawn. Come on with liberty as written.
Instead of using the word dismissal, my lord, close, my lord, close. I am being item 9. I'm deeply obliged.
Item. Yes. What do you want, Mr. Counsel? What is your prayer here? To disburse the area salary of the petitioner. For which period?
From 1/11/22, 1/2/2020,
1/11/22 to
1/11/2020,
20, my lord.
2020.
so for 4 months.
Oh, my lord,
For 3 months. Huh?
1/11/2020, my lord.
1/11/22.
20, my lord.
20.
26 months.
2020 to 1/2/23.
Three.
And you filed a writ petition earlier?
Yes.
What was the order passed there?
It is there in the page number. The page number 41.
Page 41.
Explain my case. Where I have a permission to read.
Huh?
Very small.
Yes, yes.
I am reading from the paragraph number 3.
See, there.
The petitioner before this court were accommodated that the tutor in L3 F2 schools in the state of Assam by separate orders, all dated on 29,000 issued by the Director of Elementary Education Assam. The order further stipulates that accommodation order will take effect from 01/11/2020 only, and she cannot claim any benefits whatsoever in respect of the past services rendered by them prior to 1/11/2020. It is the case of the petitioner that they are receiving salary only from the month of March 2023, and they are yet to be paid their arrears salary with effect from 1/11/2020,
up to February 2023. After hearing the learned counsel for the parties, this writ petition is disposed of, directing the petitioners to file separate representations before the Director of Elementary Education, respondent number 3, within a period of 1 week from today. Thereafter, the respondent number 3, on receipt of the representation to be filed by the petitioner, shall consider and dispose the same by a speaking order in accordance with the law within a period of 2 months from the date of receipt of the representation. Accordingly, Annexure D, page 43. These are the all representations. I have filed, it is filed on 3/12/2024.
Yeah.
But till date, no decision is taken.
File a contempt.
Contempt is, I did not file because direction.
Mr. Counsel, there's an order
Lordship,
passed by this court.
Yes, yes. thank
You want the same prayer is there as the earlier. The
Contempt-
prayer has already been decided.
None. Yes.
Court has said that you please go file a representation and the decision will be taken. Now you cannot come, the same prayer, how can I do?
I'll address the issue. The direction was given to file the representation within 7 days.
Huh?
Direction was to the petitioner to file the representation within 7 days. But here I could not file because there was some delay from my part. I filed on 3/12/2020. This is the reason I did not file content petition, because the content petition, the direction was within 7 days. Thereafter, speaking order within 2 months. But my part, I admit that there is a little bit fault on
So
my
they might take the stand that since they did not file it within the time period, they have not decided.
No, Lordship, I am not on that. I am not submitting the court that it is to be assumed that I have filed within a time period. I have filed the representation. The essence of the order is that the representation has to be filed. And that I have filed. The main issue is already decided, that entitlement that shall be decided by the authority on my representation. So let them take decision. This is the only prayer.
Well, in fact, if he has filed a representation on 3/12/2024, then also 2 months has already gone.
No, that is, I am admitting, Lordship, that there is a
So this
little
No,
bit
he is only saying that what you all might take a defense
My-
that since
did
within
not
1
file.
week they did not file. So anyway, he just wants will. But you see, next you see what you could have always done. You could have filed a miscase in the earlier disposal of matter. That this period of 1 week should have been modified. That's all. But why the direction passed that it should be filed within a week should be modified.
Because my limitation, the petitioner should not suffer because of my limitation.
No. It is not. You see, it is not your limitation. The petitioners have submitted beyond time. It is not your limitation. It is the petitioner's limitation. What is wrong? And all your letters are dated 1/11.
But if the basic issue is that the basic.
We cannot carry on giving same orders. The majesty of the
Earlier
court also
occasion,
goes.
same orders from earlier occasion.
You see,
representation was
you
not-
file a contempt, we'll see. If they come up with that, if they come up with that defense, we will see. We cannot carry on passing
that-
same
that-
order.
that defense they will take that it is not filed within the time given by the court.
How do you know? How do you know?
It is presumption. Lord.
Please don't presume. We cannot keep on passing same orders one after the other. Because of you not complying with the order of the court. You were the one who did not comply with the order.
The same order, Lordship, on earlier occasion, I may be wrong, on earlier occasion, Lordship, the representation was not placed before the court as well as it was not filed before the authority. So as a litigant, it was also my duty to obey the order of the court. I could not. So it is a
Okay,
fault
anyway,
of
we'll
my part.
dispose it of same line. Right. Third, Mr.
Captain Mojumdar.
FZ Mazumdar, learned counsel for the petitioner, who submit that the petitioners had earlier filed WPC 4014 2020 praying for payment of arrears salary with effect from 1/11/2020 up to February 2023. This court-wide order dated 12/8/2024 disposed of WPC 4014 of 2024 by directing the petitioners to file separate representations before the Director of Elementary Education Department, department within a period of 1 week with effect from 12/8/2024. However, full stop. Though the petitioners had submitted their representations to the Director of Elementary Education on 3/12/2024, no decision has been taken by the respondent authority till date. Full stop. Next para. The petitioner's counsel submits that he has not filed a contempt petition against non-compliance with the order dated 12/8/2024, passed in WPC 4014/2024, on the ground that, now in view of the fact that the petitioners had not submitted their representation within 1 week, as had been directed in the order dated 12/8/24, passed in WPC 4014/2024. As such, a defense could lie with the respondent authorities that the petitioners not having submitted their representations on time, no limitation could be imposed on the decision to be made by the Director of Elementary Education. On considering all the above facts, this court is of the view that the entire issue can be set if the Director of Elementary Education Department is directed to dispose of the petitioner's representations dated. Representations which are at serial number, which are at annexure
Annexure D,
D, D collective,
page number 43 onward.
annexure D, page 43 to
43 to
112.
112.
112. Within a period of 2 months from the date of receipt of a copy of this order, along with a copy of the writ petition. The writ petition is accordingly approved. Director or the respondent? Who has to decide? Director has to
Director.
decide.
Director of Elementary Education.
Item?
Right. The petitioner could also then retire the cluster of a school matter. He was entitled to the MSCP, third MSCP matter from 1/1/2022, and he retired from service on 31/1/2022.
You retired on 22.
One,
You were appointed as headmaster when?
I was appointed as headmaster on 19/11/91.
Headmaster.
Yes, I was appointed as headmaster of a school, Kansai school. It was provincialized with effect from 19/11/91.
Provincialized in 91.
Mile.
And you were appointed as headmaster till then. Is it?
Yes.
What is the promotional post of a headmaster?
After that, there is no promotional.
There is no promotion.
No.
Then let us see the scheme.
Financial upgradation is, it has already been ordered at page 33,
What has been ordered?
page 33, allowed to draw the third financial upgradation under modified attitude career progression scheme, MSCPS, by DEO Kamrup order memo number so and so, dated 28/2/2022, with effect from 1/1/2022.
Yes.
This benefit has not been given to the
Okay, from
Yeah.
1 month.
It's a limited prayer fund. Has already been allowed, but benefit has not been given to the of instructor.
Yes.
Why?
I'm on behalf of AG, my lord. Perhaps we may not have much to pay. I'll have to obtain instruction.
Yes.
But let me obtain the instructor letter. Pension to I'll get out.
Okay, right. Mr. I. Shakya, Senate Counsel for the petitioner submit that the petitioner had been allowed to draw the third financial upgradation under the Modified Assured Career Progression Scheme, bracket MACPS, by DEO Kamrup Order Memo Number, it is at page 33, yeah? With effect, with effect from 01/01/22, up till there. Okay. However, the said benefit has not been given to the petition till date. Issue notice returnable in 3 weeks. Mr. G. Pegu accepts notice on behalf of
Respondent number 6.
6. While Ms. R. M. Barua accepts notice on behalf of 4. Ms. S. Tuti appears for respondent numbers 2 and 3. What about 1? 1, 2, and 3. Mr. G. Bhattacharya appears for respondent number. This is the matter after 3. Huh? 3 were it. Extra copies.
Stipended teacher, my lord is retired, my lord is my lord for pension, my lord. Your lordship already issued notice, my lord, fixed that along with that, my lord.
You are asking for arrears salary.
Along with my lord, some period of not given, my lord. That also there, my lord.
Arrears salary from which period?
March, my lord, from March 2012 to till my lord 2020, my lord. That period was not given.
2020.
But they, my lord, problem is that, my lord, last page, my lord, your lordship fix a date. Last,
Yes, what is it, madam?
My lord, they were accommodated as tutor, my lord,
not the
page 56,
not the tutor.
teacher or tutor, my lord.
No.
My lord, may page 56, my lord.
Yes.
56, my lord, after the column, my lord.
Page
So-
56.
56, my lord.
Yes.
The post against which the appointee is accommodated as tutor is purely personal in nature and will cease to exist and when the incumbent retired from the service, my lord. And below, my lord, the accommodation of teacher will get the prospective effect from 1/1/2020 only, and she cannot claim any benefit whatsoever in respect of the past service rendered by him or her prior to 1/1/2020. my lord. It is in the
That
accommodation
perception
order,
was
my lord.
challenged before, Lord. That perception was challenged before. Lord. In pair portion, your lordship. A writ of nature of certiorari shall not be issued to set aside and quash the impugned condition imposed in the accommodation order issued issued by the director limited debarring claim from any benefit whatsoever in respect of past service rendered petitioner prior 1/11/2020.
Stipendary teacher.
It is a stipendary teacher. Others are receiving all pension, but petitioner is left out. They giving this.
Perhaps, my lord, they are in the list of my irregular teacher.
Huh?
Perhaps they are in the list of my irregular teacher.
Irregularly
Irregular.
appointed. But one is irregular appointment and one is excess teacher. Correct. So he comes under which category?
This is that irregular can be rectified.
Irregular. From where? Where
But
do you
they
get that?
did not say anything.
Where is the list of irregular and
They did not do it. Earlier occasion came before.
So if you are excess, then you have got no right.
No, yes. But it is a stipendary teacher. Stipendary teacher, there is a specific condition in the appointment order that first you get 1,800 rupees and thereafter you complete it within period for basic training and they, that
petitioner completed basic training. Thereafter, she was regularized. And thereafter, 12/2000, March 2000, their salary was stopped. She came along with other came before the Honorable Court. Honorable Court directed.
Okay, we'll issue notice now. Let's
Yes, notice may same.
start with the then Bora ask for the petition. Who submit that the petition is stipendary teacher, whose service is to be governed by the Assam Service Pension Rules 1969
Right.
and not by the new pension scheme.
Right.
He also submits that the arrears salary from March 2012 to January 2020 has not been paid. Issue notice returnable in 4 weeks. Ms. S. to take this notice on behalf of respondent number
1 to 5.
1 to 5, Ms. R. M. Barwa, for
106.
6. That's all. This is the matter.
Along with my lord, the same issue, my lord.
Along with WPC
5014 of
5014 of 2024.
March.
Matter relates to, my lord, the less release of the, my lord, cash payment in respect of the deep salary.
We issue notice. Heard Mr. P. Mahanta, learned counsel for the petitioner, who submits that the petitioner retired on 1/1/2024 as assistant headmaster. The petitioner has been given leave salary for only 68 days instead of 278 days. Issue notice returnable in 4 weeks. Mr.
You, Sharma, for respondent number 1, 2, and 4,
1 to 4. Anybody else? Miss has to take for?
No.
No, you're not there.
Accountant General.
Accountant general. Who is accountant general?
Okay.
Who?
P. Borua or I.
T. Barwa for respondent number 3. Is it?
Yes.
This is the matter of the court.
My lord, this matter, my lord, relating to promotion, cash promotion from the post of what the scale, my lord, the assistant professor selection grade to senior scale. So as per the, my lord, OM, that was adopted by the, my lord, Government of Assam,
OM dated?
my lord.
OM dated.
OM dated is the my lord, this is 8/11/2023, my lord. In by which, my lord, we have
Page, where is that?
44. Yes, 44.
40?
44.
44. Ah.
Whereby, my lord, lordship will come to clause 3, where it is specifically, my lord,
From
mentioned.
the day, from the period of eligibility.
From the date of eligibility, my lord. But whenever my promotion was given from the date of notification, my lord, that is the case. So otherwise,
in the instruction.
Right.
Otherwise, there is also a representation filed by the petitioner.
so my lord, one clear, my lord. As the, my lord, we have already acquired the next stage of promotion, which is due from 23rd, one candidate and 2023 and 2 candidate for 24. So I will be allowed to for the filing the application for my next promotion, cash promotion, because otherwise, as per the UGC regulation and the
You see, there is one thing. The problem is if we issue notice, by the time everything comes here, it takes a long time. And because you want your next promotion also now.
It's due, my lord.
So if it's due, will it be better? It depends upon you. Either I issue notice or I dispose of. So should we direct the respondent authorities to take a decision, keeping in view this clause 3 of the OM?
The lordship can make.
That will be faster, I think, because by the time they file affidavit, it will take 6 months to 1 year, I don't know.
Lordship, there is a representation.
Because he wants the next promotional post.
Yes.
So basically, now you want from stage 3 to
Stage 4.
3 to 4.
Yes.
And your issue is basically stage 2 to 3.
Yes.
Right. He heard Mr. P. Mahanta, learned counsel for the petitioner, who submits that the petitioners are assistant professors who have been promoted from stage 2 to stage 3. That is from assistant professor to associate.
Assistant professor, selection get, senior get to selection get.
Assistant professor, senior grade to selection grade. In terms of the office memorandum ECF number 391244/9, page 44. Dated
8/11/2023.
8/11/23. He submits that in terms of the OM dated 8/11/23, promotion is to be made from the date of eligibility of the candidate and not from the date of the promotion order. Mr. P. Mahanta also submits that the date of eligibility of the petitioners for promotion to stage 3 bracket assistant professor selection grade was, what was the date?
Yes, my lord, that is on 25/10/2021.
All of them?
No.
25/10/21,
2021. Then my lord, 28,
comma
28/12/2021.
28/12/21 and
And my lord, 6/3/2020.
6/3/20. However, the petitioners have been given their promotion with effect from
The date of notification of
the date of their promotion, the date of the notification promoting them on
on my lord, this is 8/9/2012.
Huh?
8, no, 9/12/2024.
9/12/2023. Next para. The petitioner's counsel submits that the petitioners have written a representation dated 17/1/2024, 2025 to the secretary to the government of Assam.
Lordship, it is 14/2/2020.
Huh?
14/2.
Notification. Representation.
At page 48.
But
Top.
look at page 49.
Yes, Lordship, they have signed earlier, but it was dated 14
They have signed.
earlier, but it is dated 14/2/2020.
How can it be?
Received on 14/2, my
But Lordship, the receipt is also on 14/2.
That is my lord,
They have
probably
signed it earlier.
that was signed on January, but received on my lord on
Sent on
What have I said? Dated 17/1/2025 to the secretary to the government of Assam, Department of Education, bracket higher, comma, though the same was furnished only on 14/2/2020. He submits that the writ petition can be disposed of if a direction is issued to the secretary to the government of Assam, Department of Education, to dispose of the petitioner's representation by way of a speaking order within
4 weeks.
within 1 month.
mass of
Mr. D. Upamanu, learned counsel for the
All the response.
all the respondents, submit that he has got no objection to the prayer made by the petitioner's counsel. Next para. In view of the consent of the parties, this petition is disposed of with the direction to the secretary to the government of Assam, Department of Education, bracket higher, to dispose of the petitioner's representation dated 17/1/2024 and which was received by them on 14/2/2025. The said representation should be disposed of within a period of 1 month from the date of receipt of a copy of this order, along with a copy of the writ petition.
Petitioner letter.
Huh?
The petitioner to
I'll
submit.
submit.
He will submit, that should be.
Not one liberty may to my lord. If it is some agreement, then agree.
Yeah, that
Huh?
they want to come again to the thing.
If that can
There
happen,
is
my lord,
there is no bar, there is no bar,
that
there
is
is
my
no
lord.
bar.
I love
Highly of it.
that's something.
Eight legal lordship. My lord, in this case, my lord, that petitioner was appointed as an assistant teacher. And and in percentage reduction process initiated in 1992. But in the year 2001 and 2, 2001, in 2002, the name of petitioner was missing from the retention list prepared by the director, and some other person's name has been inserted. That is Nobin Burman in place of Dhiren Burman. Thereafter, my lord, the petitioner approached the district elementary education officer, and district elementary education officer, after verifying all the facts, have made the
So your case is against whom? What is the respondent's name?
It is against the director, my lord.
Huh?
Director, elementary education.
Are you sure?
My lord,
It's against his Kushal Das.
Kushal Das. No, I am the Dhiren Burman, my lord.
Huh?
Dhiren Burman.
I know, but your case is against Kushal Das.
No,
Who is this Kushal Das?
Kushal Das said I myself was dismissed from the service, terminated from the service.
Why is Kushal Das a party here?
No, I have just, if Kushal Das is not a party here, my lord, just mention the name of Kushal Das.
Why did you mention Kushal Das?
Because we are terminated by the same.
So what he will file his own case?
and
Who are
again-
you? Who are you to file?
No, again, he got his job back. But I
So-
was not.
So he got his job back. So
By
how
the
does
same
that affect?
We have been dismissed. He got his job back, but I was not.
Mr. Counsel, I think I'm going to impose costs upon you.
There is, my lord. That
You have already filed a writ petition earlier.
Yes, I filed writ petition.
Dismissed.
That has been,
Dismissed.
yes.
You filed a writ appeal.
Writ appeal I have not filed.
Who has filed the writ appeal?
Writ appeal has been filed by the Nobin Burman, my lord.
Huh?
Nobin Burman, that is the new person who has been inserted. He has filed the writ petition. Writ petition as well as writ appeal.
You see, the writ petition was filed by this Nabin Burman.
Nobin Burman, I am not Nobin Burman.
Now, this Nabir Burman had made you a party.
Nobin Burman
Yes,
has made.
you were a party.
Yes,
Yes,
that's
point number
right.
5.
Yes.
And what did this court do? What did it say?
In the writ appeal, my lord, the court has dismissed, lord, saying that already he has got the relief.
Correct. And then it has also recorded the fact
He has already got
that
the relief.
your appointment was what? Your appointment was what? What did it say about your appointment?
They have not said anything against my appointment, my lord. They have not said anything against my appointment.
Please come to page 64.
Channel 64.
Yes, please read. Learned government advocate has furnished a copy from the middle. Have you got it?
64. It's actually, the learned government advocate has furnished a copy of the order dated 14/3/2002, issued by the Director of Elementary Education, Assam. Said order in the quoted below examines the order dated 7/7/2000, D.O. Nalbari. It was the relevant records of the renewal application section. Examination of the record and reveals that the list of incumbency of the individual parts communicated by the government by letter is so and so. Directive 17/2000 has been modified by Director District Elementary Education Officer Nalbari in favor of the Kushal Das and Dhiren Burman in place of government approved Yogendra and Naveen Burman without the approval of the government. This action is taken by the Elementary Education Officer Nalbari, hereby held as unauthorized, and therefore both the district elementary education dated 7/7/2000 communicated by so and so is hereby declared as illegal and without authority. That is, the elementary education officer order has been
Carry on reading, Mr. Carry on reading.
and therefore it stands cancelled and immediate effect. So,
Carry on reading.
as the government has already cancelled the order dated 7/7/2000, the petitioner relief has been in this regard so far as prayer for directing the authorities to appoint the petitioner as a teacher is hereby declared Lordship, I am not here, my lord, but this is, they have those two persons.
Mr. Counsel, you see, what has happened is, your case, the government has found that your name was illegally inserted without approval of the government by replacing these other persons. And accordingly, the writ petition was allowed because the government had already set aside your name. Now they had gone to the writ appeal, the division bench.
They have filed this case,
Yes,
my lord.
now what did the writ appeal say?
Writ appeal says, my lord,
What?
my lord, writ appeal, my lord, from para 3, my lord, or is the entire? They have filed the writ petition.
Correct. Why have they filed? Why have they filed?
They filed because they have not been given the, they have not been appointed.
Yes. So because the single bench had said that they should be considered with other eligible persons.
Yes, yes.
So the division bench did not interfere with the order of the learned single bench. And the learned single bench had accepted the government decision
Yes.
removing you.
Yes.
So division bench has approved single bench also. So you are removed. What did you do after that?
Division bench has not said that I have been removed.
Correct. But then you went in, you filed a writ petition.
That
Where is
word
that?
is not there that I have been removed.
You have filed a writ petition, correct?
Yes, my lord.
Where is that?
My lord, thereafter they have filed one of their writ petition, my lord. In their writ petition,
Mr. Counsel, you have filed a writ petition after that,
yes, my lord.
haven't you?
Yes, my lord.
Where is that order?
Just a moment, my lord. Page 69, my lord.
Yes,
Annexure 11.
yes.
That is in the writ appeal that has been filed by the district elementary education officer, my lord. And para 5, my lord. Para 5, I'm reading para 5, page 72, the 11th page.
Yes.
Then the deponent begs to state that in the instant case, name of the respondent number 4 and 5, that is, my name is there, my lord. Respondent number 4 and 5 appeared as serial number 3 and 7 of the select list prepared by the selection committee for appointment as the ME assistant teacher at Boroma constituency under the head general area.
You see,
Accordingly,
these issues are gone, finished. I am asking you one small question. This is of a writ appeal of 2002. I am asking you, thereafter you file a writ petition or not?
yes,
Did
my
you
lord,
file a writ petition? Where is that order?
the order is not at
Yes, you are hiding facts. Give me, mister.
I have not I checked.
Where is that writ petition that you filed before the court? This court. 4040. 404, no, writ petition. 4040 of 2008. You are trying to rake up a already settled issue by hiding fact.
Just later on, my lord,
You're not bringing facts.
the director has again the division bench has asked the director to go through the entire matter again.
Where is that?
The director has gone through.
Where is that order?
Yes, my lord. That order, my page 26. My lord, this is the director, my lord, from district elementary education officer, annexure 23, page 136.
Page?
136. Annexure 23. Dated 15 to 2001.
It just says that case is under sub judice. Where is this? No, where is the party? WPC 4040/2008 is by Dhiren Burman and Kushal Das is separate. Basic for cancellation of appellate order. Okay. Upholding the order, rejecting the yes, your writ petitions are dismissed.
Hello? In my representation for a director, I have mentioned that.
Huh? I know. Is there? So, Mr. Counsel, your writ petition has been dismissed.
Yes, my lord. Now, due to the
Wait, one at a time.
due
One
to
at a
further
time.
development, my lord, I have come again.
I'm not about your further development. You have got no right. Whatever the government wants to do with you, that's their issue. But with this court, it has a 10 finality.
My lord, in my representation, page 180, my lord, I have stated that there are 24.
You are hiding facts before this court. You have not brought out this order where your
I
case was
have
dismissed.
mentioned, my lord.
Huh?
I
You have mentioned, but you have not brought out the order.
order is not there, but what happens there, I mentioned that.
Now what remains? Nothing remains. This
Page
order
180.
is there. What is your prayer? Your prayer is that you should be provincialized. Correct?
Right.
And your prayer, you have already filed a writ petition before this court, 4040/2008, which was dismissed dismissed on, what is the date of dismissal this one? Hey, bring out over the date of dismissal, it's not here.
There are two cases stacked together, my lord.
Acha. 2013, 24 July.
Two
Dismissed.
cases have been stacked together and a common order has been passed. And where this says the learned single judge is discussing WPC 4040 and 331.
Okay, right. How much cost are you willing to pay? You can go
My
to the
lord,
division bench. The cost.
I am fighting for all along. I have been fighting for the job only, my lord. And
And you cannot come to this court over and over again when it has been decided so many times.
if something has been developed in between, my
Yeah,
lord,
I'll ensure that you don't come again. You can go to the division bench if you are unhappy, right? Heard, mister?
my lord, this maybe, my lord.
Huh? There's nothing to be lenient
No
about.
cost may be imposed, my lord, because
Cost will be imposed. You have
my
got to
lord,
pay.
I have come with all my clean hands.
In
my lord.
fact, why should I not initiate contempt case against you? That is what I'm thinking. Not only cost, you should go and spend some free time, vacation, if you might want to call
I
it.
have annexed everything, my lord.
You see, your case has been heard by the single bench, by the other person, and the decision of the government showing that you have been illegally inserted in the name instead of that earlier writ petition had been accepted. The decision of the government had been accepted. The division bench also did not interfere. Thereafter, you filed a separate writ petition, not only challenging the director's order, but the acceptance of the director's order by the secretary. That has been dismissed in 2013. Now that has attained finality as on date. As on today, that has attained finality. That is your writ petition, 4040 of 2008.
Otherwise, the director has later on said that
Huh?
I've been selected.
Maybe, Mr. Kaushal, I do not know. Court has
Director
now
has said
that you see that this court cannot pass any order against that other order passed in 2013. Your decision that whether the government does something beyond after the court order, that's a thing that we do not. As on today, you don't have any right. If there is some order passed by the government subsequently provincializing you, then it's good for you. If they don't provincialize you, then nothing wrong. It's a fine. It's a closed chapter, right? What is your name?
A. Bhattacharya.
Mr. A. Bhattacharya, learned counsel for the petition. To submit that the petitioner was appointed as an assistant teacher under the OBB scheme in Gobra Dol Milan Primary School in the year 1988, pursuant to selection process initiated in 1990. While the petitioner was discharging his duties, don't cut that. Huh? The second question is just cut. The petitioner's case, in short, is that a direction should be issued to the respondent authorities to consider the petitioner's prayer in his representation dated 9/3/2019 and 18/2/2022, submitted before the principal secretary to the government of Assam Elementary Education Department in the light of the letter dated 18/7/2021 issued by the Director of Elementary Education for allowing the petitioner to work in the capacity of assistant teacher in ME school, equivalent to that of other selected candidates who are still working in the respective school, as per the selection list dated 26/4/1998. The other prayer is to allow the petitioner to work in the capacity of tutor, equivalent to that of the respondent number 4. Next, sir. You have filed another writ petition, 2651 of 2017. Give me 2651 of 2017.
4040 2008.
No, after that you filed another one. Miganko. Huh? Is it? Is he a party there? Is a respondent or something? Dhiren Burma? Right. No, Kamal Chandra Das and four others. He might be there four others. No. Acha, wait. Okay, he's not here. He's not. They have been mistakenly over, but why is it mentioned here? Okay. 2651. You see, this director's letter of 2021 pertains to WPC 2651 of 2017, not to you. How your name came here, I do not know, because 2651 is by Kamal Chandra Das and four others, not you. And this is wrong. It says here that the matter is now sub judice.
That's how they have written, I don't know. It's not-
Because this was disposed of in 2019, and your order of the director in your favor, not in your favor exactly, but just mentioning your name is of 2021.
21. They might have
There's something which is beyond our knowledge. Anyway, right, whatever. The petitioner, next para. The petitioner's case is that he was appointed as assistant teacher under the OBB scheme in Gobardol, Milan Primary School in the year 1990, pursuant to selection process initiated in 1996. While discharging his duties, in the retention list prepared by the directorate for the year 2001, 2002. The name of one Nabin Barman was shown in place of the petition. However, the district elementary education officer Nalbari corrected names the name of the person who was to be retained by replacing the name of Nabeen Barman by the petitioner, by order dated 7/7/2000. The next para. The said Nabeen Barman, being aggrieved by the replacement of his name by the petitioner herein, filed WPC 6557 of 2001, along with one Jogen Chandra Das, whose grievance was against one Shri Kushal Das. Thus, in WPC 6557 of 2001, the petitioner Dhiren Burman and Jogen Chandra Das had challenged the retention, had no, not sorry. Uh, no, just read it from the beginning wrong. I made a wrong statement. No, not from the beginning, from the starting of the paragraph. Just being aggrieved. Uh, uh. Not the petitioner. Shri Nabin Burman and Shri Jogen Chandra Das filed challenge the retention proposal of the petitioner herein, petitioner herein, and Shri Kushal Das. Next para. WPC 6557 of 2001 was disposed of by order dated 20/03/2022. In terms of the order dated 14/3/2022, no, 2002, 14/3/2002, issued by the Director of Elementary Education, ASAP, which is quoted below as follows. Page 64, from here to here. Okay. Next para. This court, in its order dated 20/03/2022, passed in WPC number 6557 of 2001, thus held that as the government had already cancelled the order dated 7/7/2000, by which the petitioner herein had been retained in place of Sri Nabin Das, Nabin Burman, comma, the state respondents were directed to consider the case of the petitioner, the case of Nabin Das, along with Nabin Burman, along with similarly situated persons, for their appointments as assistant teachers in the school. Next part. Shri Nabin Burman and Shri Jogen Chandra Das were agreed by the order dated 20/03/2002, passed in WPC 6557 of 2001. To the extent that the learned single judge had committed an error in not setting aside the orders of appointment of Shri Kushal Das and the petitioner hearing. And as such, if the the government could not be able to pass an order appointing Shri Nabin Barman and Shri Jogen Chandrada. The division bench, next para, the division bench, while order dated 24 to 2025, no, 2005, 24 to 2005, passed in WA number 157 of 2002, stated that the state government had already nullified and cancelled the appointments of Sri Kushal Das and the writ petitioner herein, leaving no scope for redressal, for leaving no scope for for directing the government to appoint Shri Nabin Barman and Shri Jogendra Chandra Das. It held that the division bench held that the learned single judge had rightly passed the order to the government to consider Shri Nabin Barman and Shri Jogen Chandra Das for appointment as assistant teachers along with all other eligible candidates. Next part. The petitioner's counsel submit that subsequent to the above event, the Director Elementary Education Assam has issued a letter dated 18/7/2021 addressed to the principal secretary to the government of Assam Elementary Education Department, stating that the petitioner's service was terminated by the DO Nalbari in pursuance to government order dated 22/2/2008, and that the petitioner had drawn his salary with effect from 12/11/1998 to 16/7/2008. The letter also stated that the petitioner had filed a writ petition, had filed WPC number 2651 of 2017 for regularization of his service, and that the matter was now sub judice. Next, the the petitioner's counsel submit that in view of the letter dated 18/7/21, issued by the director. The petitioner should be allowed to discharge his duty as assistant teacher in Gobardrol, Milan, ME School, with all consequential benefits. And in the meantime, he should be allowed to discharge his duty as tutor. Next paragraph. Miss S. Tutia, Learned Counsel for the no, 120. Submit what? Submits that the petitioner has submits that the petitioner's case has already been decided by this court in WPC 4040 of 2008. And as such, nothing survived in this writ petition. I have heard the learned counsel for the party. As can be seen from the order dated 20/03/2002, passed in WPC 6557 of 2001. The director's order dated 14/3/2002, which had been upheld by the, which had not been, disturbed by the single bench. Comma. The DEO Nalbari had inserted the writ petitioner's name instead of Sri Dhiren Burman, illegally and without approval of the government. In WA number 157 of 2002, the division bench in its order dated 24/02/2005 had clearly stated that the state government had already nullified and cancelled the appointment of the writ petitioner. The above facts make it clear that there was no made clear that the petitioner this petitioner as a prayer for continuation as an assistant teacher had not been accepted by the government or by this. Next part. The above being said, the petitioner had also filed WPC number 4040 of 2008, whereby it had made a challenge to the order made by the director. No, whereby it had made a challenge to the order dated 20/02/2008, passed by the Commissioner Secretary Education, upholding the order of the Director of Elementary Education, rejecting the claim of the writ petitioner herein for appointment in terms of the selection made earlier, in terms of the appointment made. A coordinate bench of this court had in its order dated 24/7/2013 dismissed WPC 4040 of 2008. The above fact would further clearly would further shows that the petitioner has no right to be retained as an assistant teacher of the said school, and no and as no challenge has been made to the orders passed in the earlier into in all the other cases mentioned in the foregoing paragraph. No right survives on the petitioner to claim any further appointment as assistant teacher. Full stop. Next paragraph. The only issue that remains is whether the petitioner can have any right to be appointed by the government in terms of the letter dated 18/7/2021 issued by the Director Elementary Education Assam. Comma. Full stop. The contents of the said letter dated 18/7/2021 issued by the director is reproduced herein below as follows. Page 158. Huh. A perusal of this above letter, contents of the above letter, does not indicate in any manner that any decision has been taken by the government that the petitioner should be appointed or allowed to continue as an assistant teacher of the Gobradal Milan ME school. In fact, on obtaining a copy of the order and case, that is WPC 2651 of 2017, it is seen that the petitioner is not a party in WPC 2651 of 2017. In fact, WPC 2651 of 2017 was disposed of on 19/9/2019. On the other hand, the director's letter dated 18/7/2021 states that WPC 2651 of 2017 was sub judice. The contents of the above letter are either patently wrong or has somehow been changed or has somehow been fabricated. In any event, neither does the letter dated 18/7/21 issued by the Director Elementary Education Assam have any bearing on the petitioner's claim for appointment as assistant teacher, nor does the petitioner have any and neither is the petitioner a party in WPC 2651 of 2007. On considering all the above factors, this court is of the view that no right of there is no there is no ground for this court to allow the writ petition. The above being said, this court finds that while the petitioner knew very well the facts of the case, he has not been fair to this court as he has not brought proper facts before this court with regard to WPC 4040 of 2008. He has not submitted, he has not annexed a copy of the order in WPC 4040 2008, which had dismissed the petitioner's claim.
That I have mentioned, my lord, that is in dispute.
It is no, you do not pass the
Sir,
narrative. Next, full
that
stop.
is-
Further, though the petitioner has relied upon the letter dated 18/7/2021 issued by the Director Elementary Education for regularization of his service in terms of WPC 2651 of 2017, comma, the petitioner knew very well that he was not a party in WPC 2651 of 2000. In the case of KD Sharma versus the Supreme Court has held that. Okay. On considering all the above facts, this court is of the view that the petitioner has been trying to lead this court up the wrong garden path intentionally. He has also not only wasted the time of this court, but has also not submitted all the required documents. He has instead tried to play hide and seek with facts, which cannot be allowed. Though contempt proceedings can be drawn up against the petitioner, this court is of the view that payment of cost would be enough to serve the interest of justice. So accordingly, the writ petition is dismissed with cost of rupees, how much? 10,000
5,000
to be paid
5,000.
within a week from today. Within a week from today, the registry shall list this case again after a week with a note informing and stating as to whether cost has been paid by the petitioner or not. If you don't pay, then you're going to, in contempt proceedings will be drawn up.
Maybe 5,000, my lord.
The cost will be payable to the who? Huh? Okay, employees. You cannot, you see, your file is your case is very thick. There are a lot of hidden things inside. You cannot play around. Division bench has also stated that your appointments were cancelled. Then on top of that, you file a writ petition. And then on top of that, you rely upon the director's letter speaking of WPC 2651, in which you're not a party at all. And it was also disposed of in 2019 and director's letters of 2021. I don't know, there's something not connecting. I am not going further into it. We don't have time. Otherwise,
I mentioned, my lord, everything. 4040 is there and
Huh?
it has been dismissed. 4040 has been dismissed. I have filed 4040, which has been dismissed by the honorable court. That I have mentioned.
you have not produced the record, the judgment. We need 2651, you have not produced. 2651, you knew very well that you are not a party there. But you are trying to take advantage of 2651.
Maybe 5,000. Lordship,
No. I think 10,000 in today's today's well. I should have imposed more. Yeah, lucky I have not initiated contempt proceedings against you. Yes,
Just served the, he had to place his case.
it's already placed.
No, your lordship, on the last occasion, he had not even served a copy on us. And so therefore it was never even considered. Let him place his.
He needs that, admission
Admission of.
of his son.
Your lordship, there's no pleading to the effect as to why he's
Huh?
asking for the admission. From my verbal instructions, which I have obtained today, what has happened is that the child had applied for 3 schools. One
Okay.
in New Bongaigaon, one in Kokrajhar, and one in Borpeta. Now the child could not clear Borpeta and Bongaigaon. He went to Kokrajhar, which was in August 2024. Thereafter, he took admission there. However, the child, to my knowledge, we are trying to get the records of the case here because there are 3 different schools involved. To our knowledge, what has been instructed to me today is that he has attended only 2 classes in Kokrajhar. Out of the 156 days, he attended only 2 days. And in fact, the child is continuing to study in Borpeta in a private school since August 2024. Now, in the meanwhile, yes, there is a policy decision saying that a state government's employee, if the state government employee
Is
gets off
transferred.
work, then the child would be accommodated. However, that is subject to a rider that the school strength of the class should not exceed 40. That I'm placing before your lordships immediately. In Borpeta right now, we do not have the vacancy because the entire class of 1 is filled with 40 students. Therefore, before he took the transfer certificate, he ought to have confirmed whether Borpeta would be able to accommodate.
But
him.
you see, transfer certificate, transfer, so he has to go on transfer if he's transferred.
The child can continue in Kokrajhar. He can.
How?
This
How? Assuming he's a single parent, then what happens?
Lordship, he has, like I said, the child is continuing only for 2 days. I don't know why he took the admission in Kokrajhar is something we do not know. Because the child has not attended classes in Kokrajhar at all. That is what. Now, his
Anyway,
transfer
that
some discrepancy in the certificates, which my learned friend has also annexed. Lordships will find that his transfer order is of 2025.
for a counsel who has not received a copy of the writ petition, you seem to know quite a bit.
Served on me on last Friday itself.
Okay.
So Friday he served and we have gone through the details. I've tried to get the instructions. The documents have not come to me. Verbally, I have been instructed all of this. If you're also
No, the thing is, the one thing is that, you see, Kokrajhar, why he has taken admission or why he shouldn't have, that is not an issue here. He has been given admission there. Correct?
Kokrajhar, yes.
Yes.
Then we have no difficulty
So,
if the child continues in Kokrajhar.
let us see. Now, if he goes,
Strength in the class, your lordships. The guidelines.
let us see the
very clear.
guidelines. What
Yes.
are the guidelines?
I'm taking your lordships to that. This document, your lordship.
Yes.
This is the covering letter which they have issued. If your lordship will find, lordships will take up this letter first. This is the amending letter whereby they have increased the class strength. Earlier, it used to be less than 40. Now it has been increased to 40, your lordships.
Which letter? Okay, this letter.
This is the 19/4/2024. Yes, your lordship. Your lordship will take up clause B. This is the class strength and the competent authorities. Now for class 1, extra copy nothing.
Yes, I've got 2. You can
Oh.
give. Yeah.
So your lordships will find that for class 1 up to class 1, this has to be only up to 40 students.
Up to 40, class
Up to
1.
Class 1. The problem in Borpeta right now is that the class strength is complete. Now, the only way we can accommodate the child is your lordships issue a direction to us categorically saying that the child
No,
needs to be
okay,
accommodated.
what happens if there is not enough seats, then they're supposed to find alternative arrangements?
Yes, sure. Or the child can continue in Kokrajhar wherever he has taken admission for at least for this session. And then in the next session, we can try and accommodate the child. That is the case.
My son is a student of class 1. He is
Class
now
1.
Class 1. So my posting is there in Borpeta, but my learned friend is submitting. It is not practically possible. He will be staying alone there.
Your wife
And my wife is staying with me.
is staying with you,
Okay.
not staying with your child.
No, child is staying with us along with me and my wife. Lordship, as my friend has submitted.
No, but you see, one thing is this. If class 1 only 40 students are allowed. Supposing 20 officers get transferred, and now that out there, there is 40 students already there. Then to accommodate 20 another 20 other children will be a problem. Out here, okay, maybe one, but I'm saying you're going to look at the big picture.
This is now fixed as per the RTE Act, your lord. So we cannot go, being a central government authority, we cannot go against the guidelines which have been issued by this Ministry of Education. Fixing the the parent or the teacher and student ratio, that is fixed. We cannot go beyond that. That is the top.
42 or 40. I'm not on that, Lordship, I'm on the guideline. The guideline clearly says that admission of the student studying in a KB on transfer of the parent is allowed anytime during the session in another KB. Transfer certificate is issued on request of the parent in prescribed form. So issue is that I am a state government employee. Earlier my posting was there. When my service was transferred to Corpeta, it is categorically and candidly mentioned in the transfer certificate that CC is issued because of the parent is transferred.
Where is the transfer? Right?
Yes, Lordship.
Totally illegible document, your lordship, unfortunately.
Page, Annex C, page 30.
No, page 14, your lordship will see
It's the original one. I am taking the responsibility. I have not misquoted anything. If my friend asks me.
It's not a matter of trust.
Class?
Class 1, Lord.
Well, what about word class second?
No, it is one class 1B, that is section.
In word. Class second B? How can it be second B? Class 1B and class second B is different. Have you got that word?
Pardon, Lord. Class 1B.
You bring the original, the transfer certificate. Have you got it with you?
Yes, yes.
You bring this. When do we list it? Madam?
Lordships, let me file my affidavit.
Where?
Yes, in the-
One week.
Please not get admission here. So
You please give me this original of page 13 or 14, whatever it is. I cannot read it.
Yes, lordship, it's absolutely illegible and there's a slight, my.
You bring this original.
And Lordship, it may come up tomorrow, day after tomorrow, I'll place the original.
Day after tomorrow, madam? What? Or when can you file an affidavit?
I lordship put the affidavit some more time because we are trying to get the documents, the original which we have. Because the original TC is always issued to the parent. We are only left with duplicate copies. So we're trying to get the TC from Pokrachar, which might take one more day for us. So at least 3 or 4 days time to file the app. Otherwise, if you lordship only for
Thursday.
Thursday, lord.
There's the matter on Thursday.
Uh,
The petitioner's counsel shall produce the original of page 14 on the next page. Yes.
Otherwise, the training are complete. I think
What?
on a hearing.
So what is this for? Pension, rate of pension.
Pension.
You're claiming what rate are you claiming? Pension.
Pension, Lordship, what has happened? For a particular period earlier, I had worked in a sanction book. Then I went to work as a principal of a venture company. Now there.
Okay. So you're basically your issue is with regard to the computation of the qualifying service.
Computation of qualifying.
Correct.
Yes. The earlier.
So how many? So there was some period which were not counted.
Not count.
What was that period? The period that you were out.
Lordship, I had worked,
You are not sure of the fact.
no, earlier I had worked in MC College for more than 10 years as a lecturer.
Okay, we'll fix it on other days, right? The counsel for the party submit that pleadings are complete, and accordingly the matter may be taken up on some hearing date. The matter relates to computation of the qualifying service in relation to the pension payable to the petitioner. The petitioner's counsel submits that the entire qualifying service of the petitioner has not been taken into consideration while calculating the pension payable to the petitioner. This is the matter after 3 weeks.
Probably on a hearing.
When?
On a hearing, any hearing. 22nd. 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 अच्छा, hello. 20. Matter relates to days from retirement, release of days from retirement benefits for the service rendered by the deceased petitioner's deceased husband, my lord,
Huh?
who died in her furnace 2/7/2014. Petitioner husband was appointed as assistant teacher in the year 1989, my lord. His service, his salary was stopped from August 2007, my lord. He died, my lord, 2/7/2014. Till the date of death, my lord, he was continuous working as a
Mr. You had filed a writ petition earlier.
yes, ma'am.
But what did you claim before this court on your in your earlier writ petition?
Lord, for release of arrear and current salary.
Arrear and current salary.
Yes.
Yeah, your husband died when?
2/7/2014.
14.
Yes.
So 2014 he died. Now, but you filed the writ. When did he retire? Yes, when did he retire? You got no idea.
No.
If you have got no idea, I have totally lost. Unless you guide me. It's your case. Your client. Okay, what are you praying for out here?
The arrear and current salary.
Arrear and current salary.
Yes, madam.
For which period?
Lord, from August 2007.
From August 2007.
Earlier,
From August 2007.
earlier bits of restitution was disposed on my lord 27/4/2012.
Huh?
27/4/2012.
What?
Kindly see my lord annexer.
Actually, Mr. Consul, when did he retire? I want to know. Because
My lord,
he died, the earlier writ petition was disposed of in 2012.
in the
Correct.
course,
What did you claim in that earlier writ petition?
my lord, arrear and current salary. My lord, he was
Arrear and current salary.
continuously working, my lord.
So you applied, you asked for arrear and current salary. And what did the court say?
My lord, examine, my lord,
Page
42, my lord. Please start from, my lord, page 36, annexure I.
who is the petitioner?
My lord, petitioner number, my lord, 8.
Petitioner 8 is the husband of the present petitioner.
Yes, my lord.
Okay. So this was disposed of on
24/7.
27/4/2012
12.
with the direction that we'll examine the case of each and every petition. Correct?
Yes,
Now, did the respondents examine the case of each and every petition?
yes, my lord.
Where is that order?
5/5/2015, my lord.
5/5/2015. So,
Annexure J, my lord.
yeah, yes. What does it say?
Findings, my lord.
Yes.
And as the so cause notice were issued to the petitioner and the replies of so cause notice were not satisfactory, and as such, the petitioner were terminated from the service during the month of May 1992 after giving 29 months salary.
So you are not entitled, according to this order,
Yes, my lord.
you are not entitled to anything.
Yes, my lord.
So has this order been
Yep.
challenged?
My lord.
Has this order been challenged?
Yes, my lord. I have challenged this order, my lord.
We challenge it now.
Yes, my lord. Thereafter, my lord, before, my lord,
I've got a meeting. After at 2. What is to be done here?
Otherwise, my lord, the pursuant to the order of this honorable court, we were asked to produce the list whereby he was terminated. His husband was terminated. So produce the list. He was already terminated after the so-called notice was issued because these were the teachers who were appointed against non-existing.
Okay.
my lord,
And
this
by giving
petition of my
29
lord-
months salary, they were terminated. And that order makes it very clear that after 92, even if they have served, that no salary will be paid.
My lord, these all these petitioners, my lord, they have again come before this honorable court. This honorable court dispose of this petition, my lord, as a regular teacher to release the whole benefit, my lord.
That's sort of
I
part of
order, my
record, I don't.
Is it part?
And
It's
yes,
not a
my
part
lord.
of the record.
You give
Again,
it,
my lord.
you give him a copy of the order.
I have copy, my
You have copy, I don't have copy, he doesn't have copy. You write the order, what do you want? We don't know anything. You have to give us a copy also. You give him a copy also.
Yes.
Don't say I have. You might have it in your house, wherever, but he needs it also.
next Thursday, my lord.
Yes, so what is to be done now out here? Readings are complete.
I think it's not completed.
They have not filed affidavit.
You have not filed affidavit.
We have not filed affidavit. Pursuant to that order, my lord, we have produced that list of the terminated, where the petitioner's husband name appears as serial number 48. You will find that in the last order, my lord. It was reflected in the last order. And that list is marked as a
Last order is on the prayer of friends, so this one line order.
the argument. And it was marked as X. my lord.
This list. Tarun, not approved by the government for accommodation.
Or we'll file it by way of an affidavit, my lord. We'll bring it up a copy. Give him a copy.
My lord, already, my lord, so many occasions they have given the taken one time.
Huh?
So many occasions they have taken time, my lord. The honorable court already 5/11/2017, my lord, the respondents are given as a last chance to file affidavit, my lord. Till that month, they have not filed.
Yeah, why not file it?
It is reflected, my lord, similarly situated person already disposed, my lord. In annexure J, my lord, petitioner, annexure petitioner number 1, it is put in the wife, my lord. He approved order on approval.
This is writ petition of the state report is honorable court, my lord, along with this writ petition, my lord. It is clear, my lord, para 3, my lord. Page 3.
Yes.
In this case, the husband of the petitioner had died on 28/8/2013 and claiming release of arrears salary under pensionary benefit. This writ petition was filed on 17/3/2017 and rule was issued by order dated so and so. By order dated 5/11/2017, 2 weeks time granted as a last opportunity to file affidavit. Thereafter, at the instance, the standing council of the elementary education department, the matter was adjourned on so and so date, which that it was made clear that no further time shall be given by further providing that the writ petition shall be disposed of on the basis of material on record.
Give them last chance to fight.
Hello.
Last chance.
But I may be given a copy of this also. But
Which one?
the order which he has handed over.
WPC 1672 of 2017. WPC 1672 of 2007. Arena Fukan Data. Was state of right, Mr. B. Kaushik, Learner Standing Council, Elementary Education is granted. How much? 1 week?
weeks.
2 weeks time to file affidavit deposition as a last chance. Miss, huh? Have you filed affidavit? Are you
Yes,
filing?
file, my lord.
List the matter after 2 weeks.
My lord, this matter is pertaining to shifting of a school
Huh?
building, my lord, school building.
Yes.
My lord, actually a plot of land measuring 1 bigha was allotted for 4 numbers of institutions, my lord. School, Muktab, Masjid, and Idgah field. And in between, my lord, the field is vacant, my lord. My lord, the prayer of the
So
petition
the field is in whose name?
field in
Is,
My
is
lord,
there any pass on the field?
for all the institutions, my lord. Page number 11 may be seen, my lord. This is the Sita copy, my lord. Annexure A. Last 3 lines, the number of Bodhisattva village under Cook Chairman Moza is mutated in the name of 4 common institutions: Bodhisattva LP School, Bodhisattva Dhamma Mosque,
Page?
Subahi Muktab, Idgah, my lord.
Para?
Page number 11, my lord.
Ah.
This is Sita copy, my lord. Annexure A.
Okay, okay. Huh. So form 4 common institutions.
Common institution. In the middle field is lying vacant. in the northern side, another place is vacant, my lord, for constructing any building, my lord. So prayer of the petitioner is that the building should be, my lord, they are in the northern side of the area, my lord. So in the middle part should be vacant, my lord, for the school program, my lord, and some other social program, my lord.
So who is building a building? Who's constructing a building?
Building of LP school, my lord. Police or LP school. So simple prayer is there. The building should be there in the northern side in the packet. So in the
Whether
middle
this
part
is
should
an
be
issue to be decided by a writ court.
my lord, lordship, my lord, some orders were passed by the.
You see, there are four institutions.
My lord.
There is a common field in between. Whether this High Court should decide the issue
My
like
lord,
this.
the petitioner.
Shouldn't it go before the authority?
Authority, my lord, the petitioner went to the authority, my lord, by submitting a representation as well as petition, my lord. Those were considered, my lord.
And
They are,
where is the decision?
my lord, the decision, lordship may kindly see page number 22, my lord.
Yes.
Page
No,
number
no.
22 is a
Yes.
order passed by the district magistrate, my lord. Both the parties present are the parties. First party claims to be a member of IFCA committee.
Come to page 20, 20.
23.
Ah.
23 is the order, my lord. After passing this order, my lord, the building construction
Come to
was
page
stopped.
23.
My lord. Page number 23 is the order issued by the additional district magistrate, my lord. Order dated 9/11/2015. May I read, my lord? Since the case record today, concerned lot model is present with the record, which are verified with original. None of the institutions have any settlement allotment order, and any possession have been recorded in respect of the land in question in field, as none of the institutions has any order of allotment settlement. The case is disposed of with a direction to the circle officer Dolgao to examine the whole matter in the light of the procedure laid down in AIRR 1986 and take necessary action as per rule. Thereafter, my lord, the construction was stopped for a time being.
No, so what is the circle officer's decision? Where is the circle of officer's decision?
My lord, decision, my lord, the petitioner is not aware what decision was done, my lord. My lord, ultimately, my lord,
You are not aware. This is of
of
26/11/2015. How come you are not aware?
the construction was ultimately stopped, my lord, till now.
Ultimately.
Finally, writ petition and
Who are you, by the way?
interim order was passed by this.
Who are you?
I am the member of the IDGA committee.
Huh?
IDGA field committee, my lord.
IDGA field committee?
Committee, my lord.
But you have got nothing to do out there.
No, my lord, the IDGA field is the wherein the building is going to be
What?
constructed.
INCA field? How do you spell it?
My lord, it is. Lord, you can see.
INCA field committee, where is that?
Page number 13 may be seen, my lord.
Page
In the
number
petition, my
13.
lord. 1-3.
Your name is, what is your name?
Akbar Ali.
Akbar
He is
Ali.
the first party, my lord.
On behalf of the
Submitted
committee, what committee is this? On behalf of what committee?
on behalf of IDGA committee, my committee of Bodlisor Jame Masjid, Bodlisor Supahi Maktab, and Bodlisor IDGA.
There is no IDGAR committee. It only says
IDGA, my lord, is there, my lord.
on behalf of so masjid.
Yes, my lord.
Doesn't say any committee. You may be a committee of anything. How do you know? You may be in Donald Trump's party also. How does it matter? What is your right? What is your relationship to this field? Yes, Mr. Kaushik, what is it? What is this matter?
A deputy commissioner has filed an affidavit. Doctor will kindly see the affidavit filed by the deputy commissioner, paragraph 4.
Paragraph 4. Yes. 4. Yes.
This is based on the report, madam. The land in question involved with the disputation, there have been standing masjid,
Maktab Madrasa, Bodlapur LP School, provincialized, and Bodlisar ME School, part provincialized, and using for Idgah place, Janaza place, playground, and for other social functions. It is to be mentioned that one proposal for allotment of land measuring 1 bigha covered by Doc number so and so has already been approved in the SDLSC meeting held on 23/2/2016 by resolution in favor of the school. It is mentioned that the Potlisar LP school is now situated in the east side of the land in question, belonging to Doc number 170 along with Masjid and Maktab, which is situated in the western part and in the north part. ME school classes room is running. It is mentioned that the present construction of so-and-so is within the proposal for allotment of government land in favor of this. As per the report of the circle officer, the Dolgar Revenue Circle, it is stated that the LP school has already been constructed up to the shuttering level and ready for fixing the concrete mixer by expensing government money. And due to obstruction of the work, the materials of the building are now lying decaying, for which it will incur loss of the government. So the construction which is being done by the school, it is within the land that is allotted to the school. Now, my lord, the dispute which he is raising, that the school has constructed beyond the allotted land. So that matter, in my respectful submission, has to be he has to go to a civil court.
That'll have to be
Because-
decided by the authorities concerned who know more about the land. Who are we?
Yes.
So according to you, the construction is made within the land of the school,
Within the land allotted to the school.
of this LP school.
LP.
So let them decide. Who is to decide? The DC.
Basically, my lord, he will have to go to civil
Representation
court.
is
my lord.
pending, my lord.
Because-
Representation.
Now, by way of this encroachment, my lord, he is-
This construction in the middle of the school.
the lordship will kindly see the prayer in the repetition. Page 8.
Yes, yes.
Directions must be issued to the respondent to stop the construction of the building of the Bodlisar LP school and shift the building to the southern side of Bodlisar Idgah field to save the field which used for various religious and institutional and on perusal of record and going through so-called the so-called file, if any, and after hearing the parties, your lordship may please to make a rule. Basically, he's praying an injunction under Order 39 Rule 1.
But he has to show that it is his land.
His land.
Land is, my lord, common land.
Common land.
Common land for all the, as per the land record, my lord. Page number 11, my lord. There is the Sita.
Then you go to the trial court.
So
But how do you say that it is school land?
Well, the deputy commissioner's affidavit at serial number C, serial number B and C. B and C. It is mentioned that one proposal for allotment of the land measuring 1 bigha covered by so-and-so has already been approved by the subdivision level land advisory committee meeting dated 23/2/2016 by resolution in favor of the LP school.
But why, anyway, why did you construct right in the, why did they construct in the middle? It should be common land, huh? It has not been given as on it. It's just
No,
in
it
the
is
process.
approved by the subdivision level.
It is only
And-
approval. It is not, the actual giving is not there.
And the land which has been allotted is approved. In that only the construction is going. That is serial number C. Within the 1 bigha land. They possibly, my lord, the petitioners committee, they were using this land.
Correct.
But there is no allotment in their favor.
no, my lord.
You go pray elsewhere or
My-
do something elsewhere.
My learned friend is saying, my lord, but land is for all four institutions, my lord. Also the Idgah, Moktab, school, my lord, and my lord, four institutions. So it is recorded.
No,
in the
you see,
Sita copy.
no. How can you say it is for, when there is no allotment in your name, how can you say that it is for everyone? That way the land, empty space is for everyone, no doubt. But once it is allotted, then you don't have any right over the land. Have you asked for allotment of the said land for in your name? They're not-
Land was not allotted to any of the institutions, my lord. It's a
Now it
common
has
land.
been allotted. Now it is going to be, now it has been approved for allotment. So what is wrong? You have not asked for it.
My lord, they has
As-
taken,
You
my lord,
see,
the
you see,
decision.
this is the problem is, in this court, in a rate court, you can come only when some right of yours has been violated, or or the authorities are not doing their duty. Okay, now here you show me what right of yours has been violated, and secondly, what duty has the government not been doing?
My lord, the
You see,
repetition was filed,
you
my-
cannot just come under the and file any case under the sun.
my lord, repetition was filed, my lord, when the uh, grievance of the petitioner was not considered, not only the petitioner, the
You
entire
you
people, my
you
lord.
you file a PIL, then not because in a writ court you have to come with showing that some right of yours has been violated. No local
Our
sun.
only limited prayer was that the building should be shifted to northern side. Nothing else, my lord.
Sorry.
So for
You're
that,
not,
he will have to establish his title over the
Yes,
land first.
correct. He has to establish that. Yes. So anyone else is there? No. That's all. Anything else? Mrs. Saiki, yeah, are you here?
And interim order is also there.
Interim order to with lift. That's not an issue. Yes.
There is a copy of the Jamabandi.
Huh?
There is a copy of the Jamabandi, my lord,
Huh.
where it is stated that land 170 that number that allotted to the schools. But that used by the petitioner, illegally used by the petitioner. This is particular technique.
Okay. So this land has been allotted to the school,
School,
but it is used by the petitioner,
by the four institute.
by the four
Four
institutions.
No, my
So
lord,
it is school
that
land.
is not correct, my lord.
Anyway,
I am reading.
this
I am reading the Jamabandi, same
you
Jamabandi I am
see,
reading.
anyway, this is a issue. This is a issue with regard to facts. Factual issues, you go to the trial court.
That is correct,
That's
my lord.
all.
I will do that, but so far my submission of my learned friend, my lord, I am reading, my lord, from the Jamabandi copy.
No, I'm not going into that. No point. You will read it.
Land is not allotted only for the school, my lord. It
No,
is for
land, according to you, land is not allotted to anybody.
my lord.
Then it's vacant land. It's vacant land.
So, my lord, the grievance of the petitioner is very much simple that it should be constructed in the northern side. Nothing else, my lord. So, field should be vacant for the students, for the villagers.
This court is not going to decide that. This is not a PIL, first of all. This court, in a single bench, in a writ court, is only going to decide issues where some right of yours has been violated or the government has not done some duty which it should.
Our
We have
prayer
not
was
been
that
able to show either.
since the representation is pending, my lord. So, we prayed for a direction to the authorities to consider my case. That was our case.
Okay, so let the authority decide the
My
representation. That's all.
my lord.
Right, Mr.
Yeah, Ali.
A. Ali appears for the petitioner, while Mr. B. Kaushik appears for
Respond about 1, 3, and 4.
1, 2, 3, 4.
3 and 4.
3, 4. Mr. P. Saiki appears for 5 and 6. Mr.
Yeah, ma'am.
Yeah, Mami, the case is final. Huh? The petitioner, who claims to be a member of the managing committee of the Badlichar Eidgah Maida bracket field and the Dalgod police station, Darang district, has stated that, has raised the grievance that the new building of the Badlichar LP school is being built in the middle portion of the Eidgah field, Eidgah field, though the said area is the common area of Masjid, MAS, Masjid, Maktab, Madrasa, Badlichar LP School, And what else? And Badlichar, any school.
Emi.
Huh? Next para. The petitioner's counsel submit that as the open field area is the common property of all the four institutions mentioned above, the Badlichar LP school cannot construct a new building in the middle of the open field. He submits that there is a vacant plot of land on the east of the said land, correct? East of the open field in which Badli Char LP school can be constructed. Next part. Mr. B. Kaushik, the learned. No, not that. Mr. Uh, A. Ali, learned counsel for the petitioner submit that even though the petitioner has submitted a representation dated
Representation, my lord, page number 26. Dated 5/8/2017.
5/8/2017 to the district elementary education officer. No, how will he? Huh? Correct, he has got no right. Anyway, district elementary education officer with regard to the petitioner's prayer to stop the construction of the Badlichar LP school building. No decision has been taken by the district elementary education officer till date. He submits that the petitioner may be given the liberty to file a separate representation to the deputy commissioner, to the district commissioner, Dorong, with regard to the grievance of the petitioner. Next one. Mr. B. Kaushik, no, the learned counsel for the respondents, on the other hand, submit that the vacant plot of land in question, wherein the Badlichar LP school building is being constructed, has been allotted, correct? Has been allotted to the Badlichar LP school. As such, unless the petitioner is able to show that he has been allotted the area in which the Badlichar LP school is being constructed, new Badlichar school is constructed, the writ petition would have to be dismissed. They also submit that as the matter pertains to questions of fact, disputed questions of fact, the office of the district commissioner Darang would be the best authority to decide as to whether the land has been allotted to the Badlichar LP school or not. Correct? They also submit that they do not have any objection with the petitioner's counsel's prayer to submit a fresh representation, which can be decided by the concerned district commission. Yes, sir. I have heard the learned counsel for the point. The question of whether the new Badlichar LP school can be constructed in the middle of the field, small field, and whether the same has been allotted to the LP school is a disputed question of fact, which should have to be decided by the competent authority. In this case, the competent authority would be the district commissioner. Accordingly, as there is an alternative remedy available, efficacious alternative remedy available, This court is of the view that the petitioner would have to approach the said authority with his grievance. If he is still aggrieved by the decision to be made by the district authority, district commission, the petitioner can always avail of the remedy under the civil code. Accordingly, the petitioner is given the liberty to submit a representation to the petitioner with regard to his grievance within a period of 2 weeks from today. In the event the petitioner submits a representation to the district commissioner, the same should be decided within a period of 6 weeks from the date of receipt of a copy of this order. The district commissioner should also give an opportunity of hearing to the respondents prior to taking a final decision on the petitioner's representation. The writ petition is accordingly disposed of. The interim order, the status quo order passed on 11/1/2021 shall remain in operation for a period of 2 weeks from today. I'm giving you,
I will file.
by the time you go, 2 weeks from today.
That's Offline.
23 to 25. May I please, your lord? Okay, so far 23 is concerned, my lord. Petitioner was expired, my lord. I'm waiting for the instruction and documents, my lord. And so for 25, my lord, here also my petition number 10, Monica Singh was expired, my lord. So, my lord, need some time and to get documents and instruction to file subsequent petition, my lord. And other pair before lordship, my lord, 23 and 25 may be clubbed together, my lord. In between 24, my lord, it was inconvenience for the man learner brother court also, my lord. 23.
So you are appearing in 24.
24, my lord.
What is your case in 24? Who is appearing for the other side? Okay. In item 24,
24,
you write, Mr. Ellen Dehingia, and counsel for the petitioner is granted 2 weeks time to file affidavit in reply. Detach this matter from the other case. Then in the other cases, you write, Mr.
M.U. Ahmed.
M.U. Ahmed, learned counsel for the petitioners, submits that. Who has died? Petitioners have died.
23, 4 weeks time maybe, my lord. They are from the
Submits
remote
that
place.
as some of the petitioners have died,
Right.
he needs time to file substitution petition. Accordingly, leave this matter after
4 weeks, my lord.
4 weeks.
Obliged.
In this case, Lordship, the private respondent has filed their affidavit.
Huh?
Private respondent has filed their affidavit.
Yeah, let us see.
And the department and the college authorities are yet to file. Lordship.
No, let us see. What is your
Yes.
case?
Petitioner is agreed with the non-selection, Lordship, for the vacant post of assistant professor in English. Lordship. Now, what has happened, Lordship? Petitioner, Lordship, pursuant to advertisement, he appeared in the interview and he has a to RTI, he made an application before the authorities, Lordship. Lordship will come to page 30.
Yes.
How, Lordship, the serial number 5 is the person who has been selected, and page 31, page 30.
So he's respondent number 5.
Yes, and serial number 34 is my
Page,
petitioner, Dr.
page.
Mukul Kumar Sharma.
Page.
But you will come to the teaching skill, teaching experience,
Uh,
conference
That
seminar.
Mukul Kumar Sharma at
Mukul Kumar Sharma. Technically, no marks have been given with respect to teaching skill, teaching experience, conference seminar attended, publication, noted. Out of 10, he is awarded 3. And in the teaching experience, out of 10, he is given 1.4. And conference seminar attended, out of 5, he has been awarded 4. And in respect of publication, he has been awarded no mark.
Oh.
He,
these are subjective.
to his credit, he has several publication notice submitted various research papers, but those marks were not considered, only given 0 note.
What publications have you done?
Application I have mentioned, but these are at para number 13 of my application I have mentioned. Page 9.
Yeah.
May I read, Lordship?
Yeah.
The petitioner begs to state that marks allotted to the petitioner in respect of teaching skill, teaching experience, and publication is absurd and not based on record, and also in comparison to the respondent number 5, who is placed in first point. That the petitioner is presently holding the post of assistant professor since January 1998 in the Department of English at Bapuji College, Harukhetri, PO Harukhetri in the district of Barpeta, Assam, having an experience of more than 19 years of teaching experience and have applied to the post through proper channel, and his application was forwarded by the Director of Higher Education, Assam, Kahlipara, to the principal Guwahati College. As such, the allocation of marks in the teaching skill, that is 3 out of 10, is absurd. Teaching experience 1.4 out of 10, remark that experience certificate not submitted is unsustainable, and publication, that is 0 out of 5. When series of publication was made by the petitioner with ISSN and ISBN publication certificate is
Where is this? You did not annex any.
there, Lordship.
Then it's like saying I've been to the moon without showing proof.
I have also not been able to get through with my clients. It's a long time. Now, Lordship, somebody informed me.
This has become infectious because the petitioner, he fought this battle for assistant professor. He is now associate professor.
That I have
He
come
is
to know, but
getting
I have not
double
been informed
salary.
with the petitioner. Let me.
I have
Let
got
me-
the copy of the order, my lord, one
Yes.
of the order and downloaded version from my learned
That-
brother will confirm, but this is the
No, if then I'm not going to keep it pending. I don't find any case here, in fact.
I have no.
Right, Lord Ahmed.
If
Mukul
you
Sharma.
find that this is wrong, you can come by way of a review. And these are all marks. There's nothing. You did not submit your experience certificate also.
Exactly.
Then what is wrong?
This is
Down,
this
down, Bapu Kiboli.
is not in my knowledge.
Associate professor.
This is not in my
You will not come down and join assistant professor. Nothing survive here.
Right. Heard Mr.
A. Ganguly.
A. Ganguly, learned counsel for the petitioner. Also heard Mr. H.K. Das,
Respond number 5 minutes.
counsel for the respondent number 5. And Mr. N. Upadhyay for respondent number D. Upamanu for respondent number 1 and 5. Mr. D. Barwa, 1 and 5. Mr. Upamanu for 1 and 5. 1 and 2. Correct. The
She appeared.
5 more. 5
H.K. Das is for 5. Mr. No, the petitioner's grievance, the petitioner's challenges to the appointment of the respondent number 5 as associate professor, as assistant professor. English. English. In Guwahati College,
Guwahati College.
Bamuni Maidan,
Guwahati.
Guwahati. Where is? No, with regard to the marks given to him during the interview.
Next.
The petitioner's grievance is that the marks given to the petitioner were not, were too less. It should have been more. So, on the other hand, Mr. B. Kaushik, no, Mr. H.K. Das has submitted documents to show that the petitioner is now an associate professor, and as such, the writ petition has become infructuous. The document, the two documents submitted by Mr. H.K. Das, showing that the petitioner is now an associate professor, is made a part of the record, are made a part of the record, and marked as annexure X and Y respectively. In view of annexures X and Y, showing the petitioner to be an associate professor, the writ petition has become infructuous. The same is accordingly closed as infructuous.
Deeply.
Yes,
My lord, my lord, the petition is, my lord, the challenging the appointment order of the respondent number, my lord, 6. My lord, issue hearing is that, my lord, the petitioner and my lord, respondent number 6, both are science teacher, my lord, and the respondent number 6 is junior to the petition. That is the issue here.
and
My lord,
what else?
my lord, that it is the case of provincialism, my lord, that because the selection is not on merit, selection.
How much cost should I impose on you?
My lord, there is some other factor there, my lord. So prior, my lord, that I have also, my lord, filed an affidavit. The petitioner,
Yes, I saw your affidavit.
my lord,
How much cost?
no, may I just explain, my lord? The petitioner has approached before the Lana Tribunal prior provincialization,
Actually,
seeking provincialization.
so and then once it is provincialized, you can't go to the tribunal. No? You can go only prior to provincialization.
No, my lord, I am not saying that whatever I am, my lord, submitting and my lord, that is affidavit, because I am not, my lord, suppressing any fact.
You see,
No, my lord, let me just, I would just wish, my lord, all aspects. Prior provincialization, and during the pendency of the case, my lord, my service has been my lord, the service of the private.
what was the ground for your withdrawing your case from the tribunal?
My lord, during the pendency of the case, my lord, the service of the school has been provincialized, and my service has not been provincialized. Thereby, my lord, challenging the impune appointment of the, my lord, the private respondent, I have filed this, my lord, that writ petition.
I'm not on that.
My lord,
My question is something different.
my,
When I ask you
my lord,
something about the trees, don't tell me about the ocean.
my lord.
Okay. The issue is, why did you withdraw your case from the tribunal?
My lord, because, my lord, during the, my lord, pendency of the case, my lord, that is, my lord, for provincial, during the pendency of the case, my lord, the services of the school teachers, all the entire school has been provincialized.
Then,
thereafter, my lord, case has become infructuous.
Infructuous.
Yes, my
Let us see the order withdrawing your case.
my lord.
What does it say?
My lord, he has not suggested, my lord, anything like this. My lord, they are saying compromise.
You have not suggested you go there to that same thing and file a review or whatever. What? You go there, you say something. You go here, you say something else. What is this? We do not know.
Service matter, how can the compromise service matter?
I
My
don't
client
know.
has not,
I don't know.
client
I
has
don't
not,
know.
my
Then
lord,
you go in. Then you challenge this order in appeal. You
No,
challenge
that
this order.
That is, my lord, only compromise. My lord, that is,
No.
service matters, my lord, the things cannot be compromised.
Mr. Counsel, I have to go only by what's written.
Ma'am.
I was not there when you withdrew the case.
Ma'am.
I have not heard you. I do not know what was inside your mind.
Ma'am.
You could have said out there that the monkey was chasing the lion, might have recorded. How does it matter? For me, that is the fact.
No, my lord,
You will
service
know
matter-
better. You could always file even a service matter, supposing the court says, supposing I say in this order, supposing I say your case is dismissed because there's no question of the monkey chasing the elephant. Supposing I say that, then what will you say? If you are happy with the order, you'll keep smiling. If you're not happy with the order, you'll file a review or an appeal.
No, my lord, here, my lord,
We do, I don't know what's happened
fact is
there.
here, my lord, in the repetition factor, my lord, totally different.
How much cost?
No, here, my lord, fact is totally different. Here, my lord, how can service matter, how can, my lord, the
I don't know. I don't know. I don't know how can it how.
criminal case.
I don't know, Mr. Counsel. I don't know.
Nothing has been compromised there. And my lord, the provincialization matter.
Then you challenge this order. You challenge this order. If this order is wrong, you challenge it.
My lord, that is, my lord, how can I challenge this order, my lord?
You file a writ against this order. You file a writ petition against this order if you
No,
want.
compromise, my lord, that is, my lord, in service matters, my lord. Does it, my lord? And during the pendency of the case, my lord, and this petition is, my lord, just for a moment, I would like to draw your lord.
And then you had, you see, that you had already availed of the remedy available. You withdrew it.
My lord.
You withdrew it. Why did you withdraw? If you found that provincialization happened after you filed the case, you challenge that provincialization order in the tribunal itself. You amend your petition.
No, my lord, here, my lord, that is at that moment, my lord, my lord, there.
Yes, Mr. Anything?
School was, my lord, purely provincialized school, my lord.
Well, there is not a single whisper. When the writ petition was filed on 25/6/2021, the tribunal case was withdrawn on 23/11/2021, and that's a compromise decree, my lord. Because the prayer in the tribunal was to provincialize him, and your lordship will see the order of the withdrawal. That there was a unrest compromise arrived at the petitionary parties.
No, my lord, that cannot be, my lord. Service
That
matter.
cannot be said to be as infractor.
My lord, that is, my lord.
And apart from
my
that,
case in the
and apart from that, my lord, whether he can maintain this repetition with a certificate by an advocate, my lord. There is no affidavit in the repetition.
There is no affidavit.
There is no affidavit in the repetition.
That much I didn't see.
Page 12.
What does the Guwahati High Court rule say? With regard to
The
this petition?
repetition has to be supported by chapter 5.
Let's give it to.
My lord, that is during the time of pandemic, my lord. During
So,
the time of
so what? Pandemic will have a different set of rules.
No,
That
but we have, my lord, file pro, my lord, online filing is there, my lord, at that moment of time. And my lord, how the court has, my lord.
how this court has done, even I don't know. How the tribunal has done, I don't know. We are all at fault. Only you are the saint here.
I am not concerned with, my lord, that the persons who has, my lord, my lord, look after this thing. At that moment of, my lord, that is during the course of pandemic, man. Another, my lord, numerous writ petition is filed in the similar manner, my lord.
Another writ petition is filed by you.
No,
What is the case number? What is the case number?
Well, that has been already been disposed of.
What is the case number?
Perhaps I will have to look after, my lord.
No, you tell
Later on,
me.
I will give.
Huh?
My lord,
You have already filed another writ petition.
No, my lord, during the pandemic, my lord, I have filed, my lord, 3-4 writ petitions.
Before you, what are
Different
the,
case,
have you mentioned it here in the writ petition?
My lord.
Have you mentioned it here?
It is different case, my lord. Petitioners is different.
Oh, petitioner. But you said you filed.
My lord, I am the engaged counsel, but petitioner is different. In respect of other petitioners, my lord, having similar.
So, how does it matter?
My lord.
How does that matter?
My lord, in a similar manner, I have filed, my lord. I don't know whether
You withdraw from there and you filed again here.
No. My lord, in High Court, my lord. During the case of pandemic, maybe there might be some special circumstances, my lord, because at that moment of time, during the course of pandemic.
So, how does that have any effect here?
My lord.
You got partial hearing loss that time.
My lord, that is,
Amnesia, selective amnesia.
my lord, I apologize, whatever, my lord, my lord, that there is some persons who are there and they have, my lord, verified all the files and all, my lord. Thereafter, the case has been numbered, my lord. And I have, my lord, virtually, my lord, this matter has been taken up at a very inception. So for this affidavit is, my lord, sign is there, my lord, I put the signs. How this, my lord, things were arrived, I am not aware, man.
What to do?
Well, during at the time of pandemic, man.
Good. At the time of pandemic.
Yes, ma'am.
At the time of pandemic, good enough.
In this service copy, we have been served with an affidavit.
Huh? Acha. Here it is not here.
Yes. And in this service copy, there is an affidavit.
Then my lord, affidavit, in my office copy also, my lord, affidavit is not there, but sign is in my copy. But
Good, 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 good.
my lord, how it has happened, my lord.
I don't know. Only you know what's going on. We're totally lost.
My lord is, it is,
No, no.
my lord.
Only you know what's happened in the tribunal. Only you know what's happened before this court.
No, my lord, so far there.
You're the saint. We are the ones who are blind
No, my lord,
and just trying to
is
find our
correct.
way.
But my lord, without affidavit,
I
there.
heard. What is your name?
BK Das, my lord.
Vigita. Learned counsel for the petitioner. Also heard Mr. B. Kaushik. Learned counsel for the elementary education department. Mr. P. Saki appears for the the district commissioner Jorhat, and Miss Deputy Commissioner and Miss CM Deka appears for first point number 6. The petitioner has prayed for provincializing the service of the petitioner with immediate effect and to set aside and quash the impugned appointment in the impugned provincialization of the service of the respondent number 6 as a science tutor. Is it?
My lord.
Where is that? Where is that order?
My lord will find this order on my lord page 25, my lord.
35.
Page 35, my lord, additional.
Appointment order.
Appointment order, my lord.
Appointment order.
Page 35.
Dated 9/10/2010.
5 February 2021, my lord. There is an additional affidavit thereafter.
This is enough. The petitioner whose case is that he was appointed as an assistant teacher in science in Napomua ME School on 24/9/98. Wherever I go wrong on facts, please correct me. Okay. You're for whom, madam? You're for the private respondent. I hope you know the facts of your case or you're totally lost. What? Yes, what? You know the facts of your case. You've got the file with you. Oh, good. In the Napomua ME School on 24/9/98. Whereas the respondent number 6 was appointed as a science teacher in the same school on 13/7/2011. Is it correct? They are looking at me and saying yes. You please look at your own file and then you say whether I'm correct or not. Okay.
My lord, there is a dispute as regards to the appointment of the, my lord, the respondent number 6.
I know, that's why I'm asking her. That is your case. That's why I've said it's your case.
No, my lord, even if my lord, it is assumed that, my lord, the date of appointment claimed by
Mr. Counsel, you please wait. Let me have.
then only,
Don't
my
give
lord,
me anything. Don't give me anything.
my petition, my lord.
For what?
My copy, my lord, I have to give him, my lord.
For why?
My lord, to, my lord, verify the signature.
No, I'm not bothered about your signature. I'm only bothered about my copy.
My lord.
Your copy, you can put some comics also out there. Affidavit can be by anybody. What? How does it matter?
I do not know, like, how
Huh?
it happens, my lord.
Affidavit could have been made by my grandfather also. How do you know?
My lord, there is a fact.
We are worried about only the court record.
My lord, I apologize for the interruption, my lord. My lord, just so far my limited knowledge is concerned, my lord, during the my lord, course of pandemic, some, my lord, exemption were, my lord, granted by her. That's why, my lord, that has been passed by the registry.
In view of the above, in view of the fact that the petitioner was senior as a science teacher to the respondent number 6. The respondent number 6 could not have been provincialized. The service of the respondent number 6 could not have been provincialized, by ignoring the claim of the writ petitioner, who was most senior. Who was most senior? Cut that. Full stop. Next part. Mr. B, no, Miss, your name? CM Deka, appearing on behalf of respondent number 6. Submits. When did you join the school?
Not,
2000.
मतलब sir, मतलब as per मतलब the appointment was submitted by the respondent number 6 in the मतलब
13/10/2010.
Huh?
13/10/2010.
Submit that the respondent number 6 joined the Napomua ME school as science teacher on 13/10/2010. And the petitioner? So that he's senior. Okay. While the petitioner and you joined as?
no, my lord, at the very inception, my lord, that both are my lord, I have been appointed as a my lord, assistant teacher. My lord, he is also assistant teacher. But you may kindly see the proforma I have enacted. And my lord, after coming into existence, my lord, 2017, then also my lord, the proforma that is my lord, absolutely. But you may kindly see this.
Temporary.
Not temporary. My lord, in the provincialization school, the SMC, my lord, you should say what temporary.
Just a minute. Let her speak, Mr. Counsel.
Mal.
Let her speak. Why are you interjecting all the time? I have to hear the other side also.
Hello.
You please sit down. You
Mal.
please sit down. Yes. Submits that no, while the petitioner joined as a temporary science teacher on 24/9/1998. Then when did he become? When did he? And you were not temporary.
As per the fact stated by the applicant in their IA,
Applicant? What applicant?
they have filed one application for stay vacating.
Okay.
Because this
That is not. That's, give me the I.
Paragraph 7, madam.
Yes.
7A. It is the knowledge and information that on 7/2/1998, one Jitu Bora has been appointed as science teacher in the school. On 24/9/1998, Babul Bora, that is the petitioner, madam, has been appointed temporarily as science teacher in place of Jitu Bora, as the latter went to complete his graduation. On 25/3/2001, as Jitu Bora rejoined as science teacher, Babul Bora has been posted as assistant teacher in the school
Okay.
on 3/6/2010. And Jitu Bora resigned from the post due to his appointment as MPW in Health Department, Government of Assam. And accordingly, on 28/06/2010, the managing committee of the school, in its meetings, resolved to invite application for post of science teacher in the school. Accordingly, the applicant applied for the post of science teacher in the school. The applicant was appointed as science teacher with effect from 13/10/2010, as per resolution of the managing committee of the school.
Ah,
So their contention is that the subsequent appointment is after the responsibility. The petitioner.
Correct.
Initially,
Temporarily joined in place of somebody else,
in place of somebody
while that person went
for
when-
pursuing his graduation.
graduation.
My lord,
So that's right. So whatever.
my lord, that is not backed up by any.
Mr. Counsel, this is their submission. They can say anything.
My lord, otherwise my appointment letter is in my description. I have been appointed as a science teacher.
I'm not on that. Okay, right. Dismiss. Writ petition dismissed, order later.
There was an interim order.
Interim order passed earlier stands vacated.
This case relates to non-payment of salaries.
Lordship, here the petitioner has filed an affidavit on the in reply.
Huh?
On the last occasion,
Item?
Lordship, 28.
28, man.
Lordship, I pray some more time to seek clarification on the affidavit in reply. Lordship, may take it up after 10 days. Lordship.
Yes, what?
Lordship, the petitioner has filed an affidavit in reply to the affidavit we have filed. Lordship, there one document they have brought on record, which was not known to me by filing the affidavit. For that purpose, Lordship, I have sought for some
There is
clarification.
nothing. What clarification? You come to the order passed by this court earlier.
Yes. It's already-
The 16/11/23.
Yes.
More than 1 year, 4 months have gone.
Lordship, but very, Lordship, may kindly take up our affidavit. In paragraph 4, we have stated, Lordship, we have placed a supplementary demand, but till now we have not.
That is then that is the issue. The issue is you have admitted to that you are liable to pay them.
Yes.
Then
But the only that the document that was annexed to the reply, Lordship, only that clarification.
what clarification? What document?
Annexure B 172.
Yes.
He has no knowledge about this job. But he becomes. He has no knowledge about this.
Sometimes, Lordship, some documents are not. We prepare the affidavit on the basis of the documents that are given to.
No, how does this? How is this relevant? How is this document relevant?
Lordship, may kindly look at the paragraph 3.
Yes.
Whereas the process of liberalization of similarly situated third numbers of reinstated grade 4 staff of upper primary school is not completed till date. In this regard, a proposal letter has sent to the BPC authority by dated 30th March 2020 with reference to your letter dated 27 December 2022 in order to obtaining approval for completion of regularization of services of the associate grade 4.
So how is this relevant to this case?
Lordship, that Lordship, only after getting the clarification I can make further submission.
No, no. What do you want to clarify? What issue do you want to clarify? Out here, they have been regularized.
Yes.
In this case, this document doesn't have any relevance.
Because lordship, they were terminated and reinstated and
Correct, they were regularized.
They are terminated.
with prospective
as a
effect.
Teacher
Ah.
holding the post of head coach.
Ah.
That is the point now.
That's the difference, lordship. Here,
This is the-
here the paragraph reflects.
because they have terminated me as a teacher, but I am holding the post of head coach. All these petitioners are holding.
Anyway,
Yes.
the petitioners have been
Since then, they have
regularized
been
from
paid.
2015
Yes, ma'am.
15
and
years.
2018. One is in 2018. All of them have been regularized.
Lordship, only for 1 week.
No,
time,
no, how
lordship.
where is the question? Why 1 week for what?
Lordship, I want to get it clarified about this letter, lordship. That
What do you want to clarify? How does it affect the petitioner?
lordship, here
Why did you put this here?
Because they have denied in their activity can be paid.
Correct.
Yes.
Yes. Therapy is very long. Okay.
Yes.
Okay. Ah.
And earlier it took time for same submitted the same pair. Till today they couldn't be able to.
The statement of the petitioner was not made against any substantive.
It by the time. That they have managed the approval officer 109 post of MPN and
Acha, page 151. During the pendency of the review petition,
yes.
the Finance Department, Government of Assam granted SIU approval for 1,009 posts. This is what you said.
1009
Nine
posts
posts.
for teachers, lordship, and the
Of
letter
LP and ME school teachers. Okay.
of teachers, and the letter that has been annexed, it shows that grade 4 staff, and here are 12 numbers of petitioner.
Yes.
And the letter also reflects 12 number. Whether these petitioners are
And they
name has been
we
forwarded,
have not
that
been initially appointed with their process of law and no salary released to the petitioner. In spite of that, we have received the salaries in the year up to 2010. Around this, that they have not getting any computation, any of sanction of supplementary. That is why I have.
Let him obtain. Mr. B.
Is this on Friday?
Give some time. Mr. B. Chowdhury,
for
Learned
PTC.
Counsel for the PTC is granted how much time?
A lordship 10 days.
Granted 10 days time to obtain instructions with regard to the letter dated 20/09/2024 issued by the Director of Education, PTC. Bracket page 175.
Yeah.
This is the matter. Of the
8 April. No? Or
Mr. Ardar appears for respondent.
next this matter, my lord, next March 28. Because this is a case of non-payment of salary. At this stage, the persons are without having salary, they are running their family. It's very impossible to run.
Okay, 8 April.
8 April.
Okay.
Yes.
I'm sorry, my lord, in item number 27,
I found the inspection method which sent by the district elementary education officer to the deputy commissioner. District elementary education officer to the deputy commissioner. Here, the factual aspect is some different matter.
In the one that I dismissed.
My lord.
Doctor has reserved the order.
Yeah.
In that matter, the facts of the applicant as stated in the IA contrary to the instruction that has been given to the
Deputy.
hospital, this would be
From paragraph number 6 onward, my lord, it will be clear. From paragraph number 6 in the instruction method, it will be clear. After repeating the complaint.
Anyway, I'm not on this issue.
Yes,
This is not the issue. I am on the other issue.
fine.
I'll keep it. I'll record this. That's all. I'm not. This is not the issue. The issue is basically that tribunal order.
Yes, my lord, that's all.
Whether if he's aggrieved, he can do something about it. Without challenging that, nothing can be.
29. Okay.
Is pending for the year 2021, sir, for release of allotment defense.
Huh?
Release of family pension to the
Yes. Who's giving this? This from the Department of School Education. Who? Yeah, yes. From Miss Fukan. So who's appearing for the Karbi Anglong Autonomous, the Inspector of Schools? Huh? You're not obtaining instructions, madam. This is 2021 matter. It's high time you obtain instructions. Some time for what? If you do not, you see, you have got to reply to this letter. If you don't reply to this letter, your officer has to come here and explain through virtual. 24 years have gone by, madam. You just cannot keep cases pending like this. Right. Miss A. Fukan. N. Fukan. Learned Counsel for the
Respondent number 1, 1, 2, 5, and 7.
1, 2, 5, and 7 has submitted letter dated 13/3/25 issued by the Undersecretary to the Government of Assam Department of School Education and which is addressed to the respondent numbers 3 and 7. Full stop. The said letter requests the respondents number 3 and 7 to furnish a proper justification for the delay in submitting the petitioner's pension papers, so as to enable the authorities to take appropriate action towards relaxation of Rule 205 read with Rule 206 of the Assam Service Pension Rules 1969.
This is regarding for if deadly submitted the papers, my lord.
Huh?
If somebody will submit the representation for release of family pension, then the earlier period be minus. Earlier period,
Has to be minus.
yes, because my lord, for the date of application.
You should get for all the period. What do you mean?
That is their relaxation.
Let me see. What is 205 and 2060? When did you apply for family pension?
My lord, it was my lord in the year 2002, my lord. But he has filed this case in the year 21, my lord.
2002.
Yes.
We do not know.
Representation case 29.
When did he die?
Died, my lord, 5/6/1980.
83. 5683. That person died.
Yes.
Who? Your husband?
Yes.
And you applied in 2002.
Yes, madam. Earlier also submitted it is also a representation. Earlier
And you filed writ petition in
21, 21/12/21.
you filed writ petition after nearly 40 years.
Yes, madam. That is why, madam.
How old are you now?
He is madam at the time of filing 6 years. My lord, the date of birth was 54, 21/1/1954. Aadhaar card.
Mr. Kaushal, your husband,
Yes.
he died when?
He died, my lord, on 5/6/1980.
How old was he when he died?
Our date of birth was, my lord, 1
Huh?
1954.
Who?
Wife.
21-1.
Yes, wife, date of birth of husband.
Huh? Date of birth of husband or
Yes,
of
yes,
the
yes.
petitioner?
Husband, my lord, I have
He was working as what? Husband.
but he was working as my lord, government employee, my lord, ME school, my lord, assistant teacher. I have annex here, my lord, for percentage. A learning report, the annex are 1, my lord, case 25.
He worked as what?
He worked as my lord, assistant teacher.
Assistant teacher.
Annex-
He worked in which school?
He worked in my lord, Vivekananda ME school, my lord.
When did he join?
He joined, my lord, that I have annex here, annex are, my lord, A. Appointment letter is, my lord, 8/6/1965, page 16.
8/6/1965.
Yes, my lord, page 16.
Page 16. Page 16. Let me see.
In Narayan Chandra.
So husband joined as assistant teacher, correct?
Yes. Eight, 9/95. 45 rupees, my lord, per month. Appointment.
And when did you get married?
One affidavit,
Huh?
one old affidavit is along with me, my lord.
We have got to know whether you are the wife of this person. So when did you get married?
First son, my gave birth, my lord, 28/12/1970.
28?
And 28/12/1970.
This is an affidavit.
Affidavit. One
It is not a
affidavit.
certificate.
Is it part of the record?
No. I have subsequently collected one
Wait, so you got married with this person in 1970?
before 70.
Huh?
Before 70 it will be.
Before 70?
Yes.
When?
My lord,
Before
because-
70 can be 60 also.
No, my lord. Our my lord first time, my lord, date of birth is mentioned as 28/12/1970.
28/12/1970. So the
Yes.
child was born on 28/12/1970.
And second was my lord 13/10/72.
13/10/72.
72. Yes.
And your age, your date of birth is
54. Oh yes, my lord. My date of birth is my lord. My lord 21/1/1954.
so when did you get married? If you had a child, when you got the child, you were just 16 years old.
16, 17.
No, 16.
54, but first, it was my lord 70.
Huh?
First gave birth one.
Yes, the first child was born on 13/10 and the 28th December 1970.
Yes.
So that means you got the child before your marriage or after marriage?
Earlier, but it was 16.
Huh?
Earlier,
So if you got the child at 16, that means you were married prior to 16?
yes.
Yes.
That-
No.
Possibly, my lord, 54. If it's 70, then 69. 69. At the age of 16 years, she was.
I think you'll have to prove you're married to this person.
But all totally, all papers are here.
Where?
These, my lord,
You see,
earlier.
now you see the problem is,
Yes.
you come to page 13.
Yes.
You come to the second last line.
At 30 minutes.
One registration number 104, correct? Page 13.
That's my husband left Naramazunda assistant teacher, Pokazan, who joined in service so and so and died. Unfortunately, my husband died on account of illness. Now I have come to
No, 1 3, page 1 3.
oh, one. A death certificate of my husband.
Hmm. This is the registration number 104, correct?
104.
Date of death is 83.
Yes.
Correct. Come to page 14. Date of registration, second last paragraph, which you did not type here.
Hmm.
Date of registration,
Yes, my lord.
2306.
2306.
He died in 83. You registered it only in 2006. And then how did you apply for family pension in 2002 if his death was registered only in 2006?
Only applications were there, my lord. Without there were the papers. Because as it is evident from
Then you come to page 14 only. You please come to the top part. This is to certify that the following information has been taken from the original record of death, which is in the register for 2004. If it is in the register for 2004,
Possible 1983 date of death.
How was it registered only in 2006?
Earlier 1983 death certificate.
You please look at page 14.
Yes,
You see, this is to certify that the following information has been taken from the original record of death, which is in the register for 2004. That means in the 2004 register,
Yes.
date of death is recorded.
Yes.
Or 83. But here, date of registration, again at the bottom, second last, is 2306.
04. 04.
04. I do not know. It doesn't look like 04 to me.
04. 04, madam. 2304. No, 04.
2304. Okay. So 04. Okay. Okay. Take it. But then you see the 4 is all different. You look at the 4 at the second top,
Different.
it's 4. This 4 is again different. This 4 is again different. Now, how many times you write 4 yourself, you will not find much difference. There'll be difference, but not much. Not like this.
All the 3 4s are different.
All the 3 4s are different.
The middle one looks resembles 6.
Yes, yes. Not only that, look at this registration number at 104 written just
104, it's
no,
different.
just before 2306.
Yes.
This 4 is again different. 4 4s all different.
What is the top?
So, Mr. Counsel, you were born in 1954,
Yes, madam.
correct?
Yes, ma'am. Correct.
You filed this writ petition in 2021.
Yes, madam. 21/12/21.
Okay.
Yes.
So 1954 to 2021, what is the age? What is the difference? How many years have gone by? 46 plus, say 46 21 will be 67. 67 in 2021. Because 54 and 100, difference is 46. 46 plus 21, because this is the date the writ petition was filed, that means 67. Let us see your affidavit. Page 12.
Everyone, it's work.
58.
Our affidavit that here is not given.
Yes.
Outdate is giving 58 years. Cannot be. You're telling lies.
But it was given, my lord.
It was given,
Yes.
given wrongly.
Subsequently, this Aadhaar card is also given to me. As
Other
is about that.
so all these. If you are 58, that means as per your affidavit here, because this has to be taken into account, in 2021, you are 58 years. That means when in 2001, you will be 38 years. In 1971, you will be 8 years old. And since you had a child in 1970,
Yes.
you were only 7 years old when you had a child. That means you got married when you were 6 or 5. Yeah, I think you are something wrong. Yes, heard.
As per instruction, my lord.
As per instruction, you got it as per logical thinking, we're dismissing it. Yeah. Where is it? Everything was correct. But age was wrong. Completely wrong. Probably not married.
It is 44 years. It's in this epic.
Mr. Counsel, I am not here. Huh?
No,
That is not the you're 44 years.
Going for my lord, where from my lord, where from it was my lord, evident that our my lord, the first son was my lord, child was 28, 12, 7.
So,
He was
so that's
44.
what in 1970 you were
1991. She was my lord, 91. She was my lord, 40 years.
40 years old. You in 1991 you are 40 years old.
44.
You are 44 in 1991. Then you filed this writ petition in 2021. That means add another 30 years to that 41. 71. Why have you made it 58?
I don't know, my lord, they have given supplied this in this all paper to the city.
You have to be fair. Yeah, not you. Your
I have
client
not
has to be
annexed
fair.
this, but I have got it subsequently, my lord.
In the Court of Judicial Magistrate First Class,
Yes.
I, Basanti, so and so, 44 years. On which date?
This is not original one.
Huh?
This is Xerox copy.
Xerox copy, my lord.
On 2/7/91. On 2/7/91, she's 44 years. But in 2021, she's only 58. She's got some anti-aging cream.
I don't know, my lord, subsequently they
Ah.
have given my lord this paper, my lord. I have not, my lord,
By 2050, she'll be maybe only 72 or something like that.
after my getting these papers, my lord, subsequently there when there was the instruction regarding her age, I have subsequently they have given me all these papers. So initially, my lord, during the lockdown time, we filed this case, my lord.
Anyway,
All verification possibly, my lord, they have this, my lord, this letter has been issued, my lord. All papers have been already submitted. I have this copy, my lord.
no, your documents you can
No,
go.
no, there, my lord, I have
You can go to civil court if you want. We'll give you the
no,
thing.
that issue is not
This
there, my
this
lord.
disputed questions of fact I'm not going to.
No, only just I want to place this letter, my lord. That was information regarding this. Her all papers were already submitted, my lord. Service book, pension, sending. This letter was issued on 6/7/23. That letter, my
You see, when you're a government servant, what happens is there's a family declaration form usually filled up. Yes, you don't even have it here.
subsequently, my lord, these papers, my lord, initially there was some one
These
letter was
papers are all after his death.
no. Citizens of have to be published, my lord. Submitted, my lord. Husband of the petitioner submitted. Thereafter, his service was regular.
So, anyway, you go to civil court. We allow you to go to civil. Okay. Third, Mr.
Is the
Is the other counsel for the petition. Also heard Miss N. Phukan for
Respondent 1, 2, and 5.
1, 2, and 5. Mr. S. Sharma appears for P. Sharma appears for point number 4. Mr. R. Rohan appears for P5 is said. Mr. P. Saigi appears for point number 9. And Miss R. M. Barwa appears for point number 6. Okay, right. The petitioner has prayed for grant of family pension on the ground that she is the widow of the deceased Narayan Chandra Mazumdar, who was a teacher of Vivekananda. Vivekananda, spelling is also B-I-B-E. Not Vivekananda, but Vivekananda. Vivekananda M.E. School, Pokajan. to arrive at a decision as to whether the school where the husband of the petitioner worked was a provincial high school, and whether the husband of the petitioner was in a pensionable service were a few of the questions that have to be decided. Were a few of the questions that have to be decided by this. However, prior to going into those issues, this court had asked the particulars, the specific particulars about the petitioner's husband and the petitioner herself, to which the petitioner's counsel has replied as follows. Next para. The petitioner's counsel submit that the petitioner was born on 21/1/1954 and had her first child with the deceased husband on 28/12/1970. The second child was thereafter born on 13/10/1972. Next para. The petitioner's husband was a teacher in the what school?
Vivekananda.
Out here the spelling is correct. Vivekananda. But
BIVE.
BIB
VIVE.
BIVE.
in the Vivekananda ME school
ME school.
as assistant teacher. Was assistant teacher on from 8/6/1965, and he died on
5/6/1980.
he died on 5/6/1980. Next para. The affidavit dated 21/12/2021, which is a part of the present petition, shows that the petitioner was 58 years as on 21/12/2021. In that event, the petitioner would have been 7 years of age when she got her first child on 28/12/1970, and would have been 9 years of age when she got her second child on 30/10/1972. In terms of the affidavit at page 12 of the writ petition, the petitioner would have been born on let me calculate. Would have been born in 1963. Would have been born in 1963 and not 1950. Next one. The petitioner has not been able to produce any document proving her marriage, correct?
Yes.
Marriage to her deceased husband, to her alleged deceased husband. Further, further there is no family declaration made by the petitioner's husband showing the petitioner to be the wife of the deceased husband. All the above questions, all the above issues, and all the above facts clearly goes to show that not so clearly implies that the petitioner is not the wife of her deceased husband.
Total list it is there.
Implies, huh?
Total list husband.
Maybe, but How can you have a child at 7 years?
Yes.
Can you have a child at 7 years? Your child was born in 1970, correct? 1970 December.
Yes.
If you are 58 in 21, how old will you be in 1970? (1970 to 2000) is how much? 30 years, correct? And from 2000 to 21 is how much? 21 years. So 30 years plus 21 years, how much? 51 years.
And if it is mentioned as 44 years,
This is not a part of the
Yeah.
writ petition. Then why should I go into this? And even if I go by this, why, if this is correct, why did you write a different age here? So next, a perusal of the death certificate of the petitioner's husband shows that the petitioner's alleged husband expired on 5/6/83, and the same was registered only on 2/3/2004. Of the even to the naked eye, the word "for" in the death certificate are different. The number 4, not the word. On considering all the above facts, this court is also that there are serious disputed questions of fact, and this court is not inclined to entertain this writ petition, as the same has to be gone into by. How can I even go into? 7 years of age you had the.
There, my lord, if there is any.
No, cut that. The dispute. This just as they are disputed, still disputed questions of facts, this court is not inclined to go into the claim of the petitioner that she is the wife of the deceased commissioner. Where is the birth certificate of the children? Is it there?
No.
There is no birth certificate of the children of the petitioner in the writ petition, and neither is there any marriage certificate. Is there any marriage certificate given? No.
Earlier it was not there. Earlier-
Don't say that. Birth certificate. On considering all the above facts, this court is not inclined entertain this writ petition. However, liberty is given to the petitioner to avail of any appropriate remedy it may deem proper as per law. You should have been more careful with the age.
I did. But at the time of filing, it was given me subsequently different.
Lordship, here in this matter, Lordship, I received the updated instruction.
Item
30, Lordship.
30 years.
Lordship, here in this matter, Lordship, I have received updated instruction, Lordship.
Ah.
There was a hearing which was conducted on 28/2/2024-25. So, Lordship, I need 10 days time to file an affidavit to that effect. I have received the instruction.
So you appeared.
Yes, I appear.
So they're going to take a decision.
They have not conveyed me that.
Okay, right, Mr. And D. Commend Learned Counsel for the Higher Education Department established that he needs to obtain instructions with regard to the hearing conducted on 28/2/25. The petitioner's case is that his service has been provincialized as a tutor assistant professor. Correct.
He joined as an assistant professor, my lord.
I know.
Yes. Now he tutor.
While his claim is for provincialization as an assistant professor.
Yes, Lord.
List the matter on. This is the matter after 10 days.
Highly
Mr. A. Das appears for this purpose.
Well, can date may be picked. All right. All right.
Seniority list.
Senior, and his regularization I have challenged. One of the issue is like this, my lord.
Are you ready? That's what I asked because I don't want to hear about it.
My lord, could I make a proposal? If this matter, because the matter is, there are 2 dates. One is he was temporarily appointed by an order dated 5th of January 94, and he had to join within 50. He joined on 50. There was a subsequent regularization order, one of whereby he was regularized with effect from 1/7/1994. One of that regularization and but my proposal, if the matter could say they could attain one of the verification of the records, the matter could be dispatched to the government of Assam to examine the record and the matter could be closed. Plus, I would also be retiring. I would lose my eligibility for consideration for principal after 1 year.
Promotion.
Therefore, if the secretary could examine the issue, matter could be disposed.
So you are challenging regularization order
Regularization of the private respondent.
dated
My lord, regular 31/12/1994 at page 29, from 29 to 31, annexure S. So I've given it type copy.
regularization.
Regular.
So that is the only order under challenge.
That is the order under challenge, and I'm challenging the seniority.
Seniority list.
Because in the seniority list, his seniority position is put from the date of his initial joining, that is 20th January 1994. If that be so, my lord, my date of initial joining is in 90.
So regularization is later.
Regular.
And your date of joining is?
My date of initial joining, my lord, is 1993, my lord. So they have given in their affidavit.
And date of regularization is?
My date of regularization, my lord, is 6/5/1996.
So here you are later.
Yes, my lord.
So they're going to take a decision as to which should be the.
Yes, my lord. And whether his regularization was proper, because that regularization does not bear any.
Yes, Mr. Counsel, therefore.
I'm for it.
Any objection that they should go to the authority?
Next week. If my senior will get. I
Not,
have not.
where is the senior?
Yes, some.
Huh?
Yeah, he was there. But he left.
Call him.
He left.
Call him.
He left the court. Next week, any day.
Why next week? Why not tomorrow?
Tomorrow.
Huh?
He has some difficulty.
Why? What
After
difficulty?
20
Who's your senior? What is his name?
monthly.
Huh? TJ Manta. Day after tomorrow?
No, but after 20.
Why? He's not coming this whole week.
Not possible.
Huh?
20, there is a function for it. 100.
When? When is the function?
20.
Right. Heard Mr. P.D. Nair, learned counsel for the petition. Also heard Mr. B. Kaushik, learned counsel for the Secretary Education Department. Mr. T. Gogoi, appearing on behalf of Mr. T.J. Mahanta.
Yes.
Learned counsel for the respondent number 6, placed for adjournment. The petitioner is agreed by the respondent number 6 being made senior to the petitioner. In the seniority list dated?
My lord, 10/1/2022.
10/1/2022. The petitioner's counsel submit that in terms of the regularization order, the service of the respondent number 6 was regularized on 31/12/1994, while the petitioner's service was regularized on 6/5/1996. On the other hand, the date of initial joining to the post of assistant teacher was 20/01/1994. In respect of the respondent number 6, while the petitioner joined his post on
5/10/1993.
5/10/1993.
as a postgraduate.
as a postgraduate. Next para. The petitioner's counsel submit that the matter can be disposed of if a direction is issued to the secretary to the government of Assam Education Department as to the basis for making the seniority position of the person in the said seniority. He submits that in terms of the regularization order, in terms of the seniority being made on the basis of the regularization orders, the respondent number 6 would be senior to the petition. However, on the basis of the initial joining to the post of assistant teacher, the petition would have to be made senior to the respondent. Next paragraph. I don't think he's going to object. There's nothing to object on. We'll dispose it over. है ना? So where is the representation? You're going to file a new
We'll
one.
file the representation.
On considering the fact that the issue with regard to the basis for the seniority is to be clarified by the state respondent, but Mr. Mohanta might want to say something. Will you want to say something? Might want to say, because it has been 2022 matters. What have I said? This court is of the view that is of the tentative view that the matter can be referred to the secretary to the government of Assam Education Department to take a decision as to the basis for making the seniority list of the incumbent there. However, as a general prayer has been made on behalf of Mr. T.J. Mahanta, leaves the matter on Friday. Friday? Okay. No, it's only on that. You don't need to be here. If he agrees, we know your junior can be there. Friday.
Deep here.
Only thing you'll have to mention that a new representation will have to be made. Mr. Nair, that DB matter, that those judgments regarding the 2013, that has been disposed of.
Dispose of the stated file a review. The review has also been disposed.
Can you give me those orders? Where is that citation? Please, I can just print it out.
Citation, I'll give the soft copy. I'll give it now.
Made clear. But this matter relating to provisional of the post of the teacher. The petitioner is a teacher of English department in Beltola Mohabbat Senior Secondary School, my lord.
Item 34.
Yes, my lord. Her name was forwarded at page 19 at serial number 4. Her name is.
Where is the report?
Report, my lord. It is not there, but her name was earlier duly forwarded in serial number 4. That she is the senior most teacher.
Yes, where is the report, Mr. Kaushik?
Two affidavits they have filed, my lord.
I know, but still, both the affidavits they have said that the report is to be made.
Two affidavits filed. Report, I.
You come to your affidavit, additional affidavit. You come to page 41. Better.
Yeah.
Same thing in the affidavit. Page 41, para 9.
Yes, please. Name. Para 9.
Come from the middle, according to the government directive. Additional affidavit.
According to the government direction, necessary steps for arranging hearing to the petitioner has been done by the director. After completion of the report on hearing of the matter of the case will be submitted to the government. I'll take an instruction on this.
Let him,
Yes.
Mr. P. Kaushik submit that he will obtain instructions as to whether the report has been completed by the directorate, which is to be submitted to the government, in terms of para 9 of the additional affidavit filed by the respondent number 2. This is the matter after 2 weeks.
Obliged.
He wants time, my lord.
Huh?
Respectfully, they will.
I was going to ask her some questions.
Yes, my lord. But I need actually only one point, that the person who is appointed, the same DP, but the petitioner was, that is the point. Petitioner is a drop, my lord. And
Yeah, excess teacher.
drop. The
Drop.
person who is working before the provincial school. The question is, the DP was sent after the provincialized of the school, but the same DP, the one lady also there. she
Okay,
was
right.
appointed
Mr. S. Tutia is granted how 3 weeks time to obtain instruction. This is the matter of 3 weeks.
Huh?
Six.
If the pattern to not pay the petitioner benefit.
Yes.
I'm appearing for the office of the AG, my lord. I've got my instructions that is dated 27th of February 2025. As on that day, my lord, we have not received the pension proposal from the
But
concerned
not only
department.
pension, they want gratuity, GPF, all that.
TTF final withdrawal application is also not received by the office of the AG till 27th.
Yes. Yeah, why don't you all print out your own? No money. Huh? Government has no money or what? 50 paisa, 1 rupee, you are always asking the court out here to print out your documents.
Well, the final withdrawal of the GPF has been sanctioned by the government on 17/1/2025, and thereafter it was sent to the office of the AG on 21/1/2025, and seeking certain clarification regarding the deputation period. Now that clarification has also been sent. The leave admissibility report has been called for the for that period. We are awaiting that, Malad, only that
Who has to give the report?
that that has to come from the Malad, the inspector.
So who's for the years for the inspector?
No, I'm not for the inspector.
Then?
And that is only of 13/3/2025. Lordship will give us 2 weeks time to complete.
Mr. P. Kaushik submits that some information is required from the inspector of school with regard to the claim of the petitioner for grant of gratuity, GPF, leave salary, pension, etc. Mr. B. Sharma shall also obtain instructions with regard to why the petitioner's prayer for grant of the above benefit, retirement benefit has not been paid. List the matter on, give it.
I'm sorry, my lord, that is not Inspector Full. It is the LR report to come from the Office of the Engineer. Leave administrability report.
Okay, instead of inspector school, we make office of the AG.
Accountant.
But we have filed our affidavit is sonic full matter.
Huh?
Independent matter of the sonic full matter.
Ah,
So we have filed that affidavit in opposition. So, madam, file reply lodge. Madam, this is a new session will start from April, my lord. So we have some urgency because already court have granted that interim order to continue his education. So we are
education is still which state?
yes, madam.
Education is still which state?
It,
The session will end when?
session, I think session will start from April, my lord.
April. So it is March now.
No, March, my lord, today is March 17th, my lord.
So we'll fix it on Monday. We'll dispose it. You fix,
Monday, my lord, they dispose of on Monday or
you file your affidavit. No.
kindly lodge. No, my lord. There is time.
Today is what date? Today is what date?
Today is 17th, my lord.
When will the session start? When will the
It will start from April, my lord.
when April? April first.
I'll take instruction.
April?
I'll take instruction.
Okay. You have to take it.
Yes.
Miss
T. Mohanty.
D. Mohanta, learned counsel for the petitioner is granted dash days, 10 days time to file affidavit in the position. List the matter on. Wait, let her obtain this.
My lord, Mr. Chisti, my lord, was granted, my lord, 2 week time on 16/12, my lord, more than 2 months.
Order of the court has already been complied with, madam.
Applied with.
While a
No,
pension
no, no,
proposal
no,
has already been submitted before the pension. But director of
No, my lord. He is not receiving family pension.
proposal has been
Let her
submitted.
produce, my lord, if they complied, my lord. So agreement order.
But madam, this is only from DEO to Deputy Inspector Schools to the director. Now this will have to go to the Directorate of Pension and all those approvals have to be
So
done.
this is from Deputy Inspector of Schools to Director of Pension.
Director of Pension is now Director of Pension has to approve.
Myra, I am not representing director.
But then you have to follow it up.
Myra,
And you follow it up. We'll give you some time to
Fine.
follow it up. Okay. Because that has to be approved. Otherwise, once we close this contempt,
the Director of Pension is not a party here. That is the.
is Director of Pension a party?
My lord, because my lord, the specific direction to DI office.
No, whatever. If the Directorate of Pension was he a party in the earlier?
My lord, yes, earlier in the writ petition director.
In the writ petition, was he a party?
Yes, yes.
Then you make him a party now.
My lord,
You make him a party.
yes.
Because now he has done her part. The rest is-
My lord, it may be kept in record whatever inspection is.
Yes,
I'll make it in record.
Huh?
If in record, we do not have any problem.
Director of Pension is a party. You make them, we plead Director of Pension.
Yes, yes. I filed, my lord, please. I am.
Right. Mrs. S. Pitya, learned counsel for the respondent, submits that the Deputy Inspector of Schools has written a letter dated 18/1/24 to the Director of Pension, submitting the pension proposal along with service book and other pension papers of the petition. He submits now that the issue would now have to be taken up by the Director of Pension. Mr.
Yes, Chauhan.
S. Chauhan, learned counsel for the petitioner, submits that he will implead the director of pension in this petition, in as much as the director of pension was party respondent number two in WPC 3932 of 2000. What is the matter after doing? You file it anytime, it will come up. Well, yes, madam.
After appeal, madam, let the come on Monday. We have filed the detailed affidavit. No, we have filed
Some
detailed
time
affidavit. No, those will be too short. Madam,
Today is
today is my lord, 17th, 24th, there is lots of time, madam, 1 week time.
27th or 20th?
No, my lord, 27, 20, then from 1st of April, that new session will start and nothing
Court
will
might
happen.
decide on it.
make it 1 week time. 1 week time. This is a matter on 25th.
25th,
25th.
1st of April.
Interim order to continue till the
26th or 27th.
So, my lord, if that day the matter not fixed, then it will take go to the another day.
It will be listed.
The listed, my lord, but not, it's not.
It will reach before this court.
26th or
My lord,
27th?
25th is okay, my lord.
26 is okay.
More than 1 week. Court has given 1 week, 26th, 25th.
26, 20.
The endowment textile, my lord, Lordship is aware of the fact that filing this review, my lord, application of 2 counts. My lord. Number 1, there is a finding by your lordship that I have not submitted the ITF for the year 2022 and 2023. That is not a fact. I have submitted. What I have not submitted is the balance sheet for the year 22. Now, there is also a finding by your lordship that in terms of clause 3B and 13H, 2 different sets of documents required to be submitted. And I have submitted 2 different sets of documents as well as the other bidders. That is also not a fact. To prove the average, there is no such document as average annual turnover document. To prove the average annual turnover, the turnover for the 3 years has to be taken together and divided by 3. So to prove the average annual turnover, this annual audit.
Why don't you go in appeal?
Because this is the actual pilot. I think my lordship will appreciate my because
Haven't you completed this job?
yes, we have already everything done over for that. The other 2 writ petitions which have been allowed by your lordship, those 2 petitioners have been empaneled.
Having?
Empaneled.
All the exercise is complete. We have already notified, my lord. Exercise is complete. That empanelment is all done. The private respondents and 2 writ petitioners, those were allowed by this honorable court. We have already empaneled. We have taken on the list of long time.
That empanelment is for how long?
1 year. It's extendable, my lord. It goes on for 5 years, my lord. That's the experience, my lord, of the petitioner. That's the thing, my lord.
No, my lord.
It carries on for 5 years, my lord. I'll be nowhere.
Right now, we have done it for 1 year.
There was another writ petition I dismissed. What happened to that?
2 writ petitions lordship had allowed, 2 lordship had dismissed. The 2 petitions which have been allowed, in those cases, the persons have already been empaneled. In this case, I filed a review. The other case which have been dismissed, my lord, the petitioner preferred an appeal. Single counsel, Mr. MP Choudhury, that has been dismissed. That is regarding ITR. I admit to that position, ma'am. I admit to the fact that it was required to be submitted. Now here, my case is totally different. It is only by way of the audited report that the average annual turnover can be proved. And if that be so, my lord, the turnover document. That's the only. So my humble submission would be, my lord, lordship may kindly recall the author.
No, I've still not understood your case.
My case is, my lord, there is a
It
report.
takes some time.
I will.
And if it takes some time, then how can it be a review?
No, it will not take much time, my lord, 10 minutes.
It has to be apparent on the face of the record. It's not by.
Yes, I'll try to impress upon your lord.
Maybe you should go in appeal.
I'll try my luck before we lost.
Release the, release the matter after 2 weeks.
I'll try my children.